All right. Good morning, everyone. We have a trial calendar call today. Cases that don't resolve today are eligible to be called in for trial on Monday, when we'll pick a jury and press forward. So I'm going to go through the calendar. We'll see who's here, which cases are being resolved today, and which we ought to have come in on Monday. Actually made a big dent in the calendar. Our first position remaining is Billy Lowe. And I think he was brought over, but we're having a little trouble tracking him down. Still not sure if he's here?
Yes, still not.
Okay, all right. If anyone bumps into Billy Lowe out there, send him this way. Alexis Scott.
Good morning, Your Honor.
Good morning, Mr. Hines. How are you?
Well, how are you?
I'm well.
Miss Scott and her baby are on the way here. I'm gonna step out if that's okay and see how close they are.
Okay.
But we're planning to move forward with the negotiated plea this morning.
And my understanding is you'd like to go earlier rather than later because you're wanted, not in a bad way, in a distant courtroom.
Yes, Your Honor.
Okay, all right. I've got that on the list of likely pleas.
Thank you, Your Honor.
You bet. Sebastian McQuwell. Hello, Mr. Fortis. There's Mr. McQuwell, Amazon vest on.
It's an unusual announcement, Judge. Number one, we are going to resolve the case by way of a plea. It will not be a trial. It's a non-negotiated plea. There's documentation that I've been waiting on from some providers, and I'm supposed to get them on Friday.
Mhm.
So it's germane to our presentation to the court. So I was wondering if I could come in on Tuesday, 8:30, plead the case.
So, Ms. Smith, what's your thought on what's happening with the McQuwell case?
I believe it will be a non-negotiated plea also.
Okay, so my thought is, Mr. Fortis, is that we divide up and today take the plea part, factual basis, Mr. McQuwell's entering a guilty plea, et cetera. He's preserved his final plea rights, so he's not locking anything in. But we would take the guilty part, or offered, or whatever this is going to be. And then when the paperwork comes in, bring everyone back for the sentencing side. So you'd be able to present your evidence in mitigation that you think you have, or whatever the records show. But we at least confirm that it's not going to be a trial by doing the plea half of the colloquy this morning.
I think that's a great idea. Let's do it.
Great.
All right.
Done. All right, Mr. McQuwell, take a seat. We'll get you up here in a minute. Mr. Godfrey was not brought over. If anyone was thinking he'd be here, per request, not brought over. Emily Browning.
Ms. Browning, I expect to be here in about 5 minutes or so, Judge. Should be negotiated.
Okay. And James Rayborn.
Judge, same announcement. I believe they'd like to track together co-defendants.
All right. Bonnie and Clyde in the same car. Great. I look forward to seeing them in person. Glad you guys are here. Is this a situation where we should take their pleas separately, or we could do a tripartite? It's going to be the same set of facts, or do they need to not plea at the same time?
I think they're fine with it, Judge. I agree, Judge.
Great. Okay. Just be a little more efficient. Jewel Nesby.
That's a plea, Judge. She's here.
There she is. Hi, Ms. Nesby.
We will be ready to go pretty soon after the call.
All right. Stringer went away. Tyrus Brown is here. And Ms. Rios, I got an email this morning indicating that's actually a plea today.
Yes, sir.
Okay. This is the case with Ms. Howard? Got it. Okay.
And we're ready as soon as you're ready.
I'm ready, but I gotta get through the calendar. All right. Elijah Kitchens is in custody.
Manifesting a plea today, Judge. So come back to us and we just speak with them again.
Okay, and co-defendant is Mr. Turner.
Your Honor, the state has made a better offer this morning. I just need to step outside and give it to her, but I believe it'll be a negotiated.
Excellent. It just seems to be the vibe this morning. And that's it with the calendar. Mr. Turner was the last position on there. So why don't we, while other pieces are falling in place, and people are talking to the people they need to talk to, was it Brown that you said you're ready? What's the one you're ready on? Let's do Mr. Brown's plea.
Your Honor, I'm waiting for the victim to get here. She said she's walking into the courtroom now.
Oh, in Mr. Brown's case?
Yes.
Okay, could we do the McQuwell guilty part of the thing? Why don't we do that, just to keep things going? Mr. Brown, take a seat back where you were. No, not there. Back on one of the benches. We gotta wait a little bit so Ms. Howard can be here. Mr. McQuwell, you're gonna stand in front of the screen and your lawyer is gonna be in front of the podium.
Sir.
Thank you.
Judge, it will be an offer.
Okay.
She's just get a bunch of yes or no's right now.
Ms. Smith, let me know when you're ready.
Okay. I'm ready.
You are ready. All right, let me check one more thing. Excellent. We got pretrial on as well. Okay, Ms. Rivers, good morning.
Good morning, Judge. I'm ready.
All right, you read my mind. We've got good flow this morning. We're going to get on the record in Mr. McQuwell's case. It is, got to get back in there, 25 SC 004-117. Mr. McQuwell is represented by Mr. Fortis. Both of them are here in court. Ms. Smith is here representing the state. Mr. McQuwell, Mr. Fortis tells me that you are prepared to enter a plea today. It's an offered plea. We also call that best interests. So it sounds like there's going to be a disagreement between your version of what happened or nothing happened at all and what the state's going to tell me happened. But you've decided that you want to go forward with your plea. Is that correct?
Yes, sir.
Okay, today, all we're going to do is the legal side of things. Ms. Smith is going to put you under oath, ask you a bunch of questions about your rights and about this case. And then I'll let you know if I accept the plea, then we stop. We're not going to get into, but wait, Judge, let me tell you more about Mr. McQuwell. That's important information that I will receive from Mr. Fortis. And you'll have an opportunity to say something if you want to, but that'll be sometime after Friday because it looks like Mr. Fortis is it medical records you're trying to get or what is it that is landing on tomorrow?
There was evaluations and things of that nature that we're
Okay,
waiting for.
of your client or of people who are complaining witnesses?
My client.
Okay, great. And you have forecast for Ms. Smith generally what it is, or this is going to be news to both of you?
I don't think that we've necessarily talked about it. It's just an evaluation.
Okay.
and Things of that I want to bring before the court.
Got it. And what is your confidence level that tomorrow is when you'll get them?
My confidence level per my client, I should be getting them on Friday through the provider.
Okay,
I feel pretty good about that.
Okay.
But I was out of an abundance of caution. That's why I was asking for a Monday or Tuesday, just in case it came in a little bit later or something like that.
got it. Okay,
But we've had meaningful conversations that we both knew it was heading in this direction.
understood. So Mr. McQuwell, as I said, Ms. Smith's going to put you under oath in just a moment. It's important that during the conversation we have, if at any point you have a question or concern, you let Mr. Fortis know or me know so that one of us can address that. Will you do that?
Yes, sir.
Okay,
This is also first offender request.
okay. Ms. Smith?
Yes, Judge. Mr. McQuwell, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Sebastian Raphael McWell.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
And is there any medication that you would normally take that you haven't been given this morning?
No, ma'am.
How old are you and how far have you gone in school?
I'm 31 years old and I got a GED.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
One time. No.
And are you satisfied with his services?
Yes, ma'am.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
Do.
Also, do you waive the formal reading of the indictment and any and all defense in the indictment for the purposes of this plea?
I do.
Mr. McQuwell, do you remember being arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
No, ma'am.
Do you understand that this is a non-negotiated or a blind plea and that the state will recommend a sentence to the court?
Yes, ma'am.
Do you also understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence for each charge?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes, ma'am.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering this guilty plea today?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes, ma'am.
Do you also understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes, ma'am.
Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes, ma'am.
Have you ever pled guilty or nolo contendere to, or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
Yes, ma'am.
No.
No, I'm sorry. I'm sorry.
You want to
No.
repeat the question?
Yeah, let's do that question again. Don't just answer yes to everything, because one of them may be, do you want to go to prison for 4 years? You say, yes, great, I know what we're doing with the
I'm
case.
sorry. I'm sorry.
Have you ever pleaded guilty or nolo contendere to, or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No, ma'am.
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No, ma'am.
Has your lawyer explained what First Offender Act is?
Yes, ma'am.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for each charge in this indictment?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistant, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Can you repeat that, please, one more time?
Real quick.
Okay.
Those are just your trial rights. And so that's what you're giving up in order to enter your, in other words, the right to go to trial, the right to talk to witnesses. So just tell you understand you're
Okay.
giving that up.
Okay. Yes, I understand. I understand. Yes.
So you understand those are the rights that you'll be waiving by entering this guilty plea?
Yes, ma'am.
Counsel, are you satisfied that your client understands that these are the rights that they're waiving by entering this plea?
I am.
Mr. McQuwell, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No, ma'am.
Are you pleading guilty because you have decided that it is in your best interest to do so?
Yes, ma'am.
Are you aware that even if you do not admit guilt, that this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes.
As to indictment number 25 SC 0041117, how do you plead to counts 1 through 3, aggravated assault? Count 4, possession of firearm or knife during the commission of or attempt to commit certain felonies, and counts 5 through 6, criminal trespass.
Guilty first offender.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you do not have a direct right to appeal from your guilty plea conviction? But if you believe that there is some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes, ma'am.
Do you understand that that process has to be completed within 30 days from today?
Yes, ma'am.
Do you understand that you only have 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes. Yes, ma'am.
Thank you, Mr. McQuwell. Your Honor, if this case were to proceed to trial, the state would show that on June 28th, 2025, officers of the Atlanta Police Department responded to a shots fired call on 2975 Greenbrier Parkway Southwest, that's in Atlanta, Georgia, and also in Fulton County. When the officers got there, they spoke with the victims, in this case, Asia Watkins and Adriana Watkins, who stated that while exiting the parking lot in their vehicle at 3030 Headland Drive Southwest, that's a Bank of America location, that they were shot at by the defendant in this case, that they previously got into a road rage incident with. When the officer spoke with the victim, they stated that while on the intersection before exiting to go to that Bank of America, the car that they were driving almost got into a wreck with the car that the defendant in this case was in. The person driving that car that the defendant was in, his name is Marquisha Brown. She was the driver, the defendant was the passenger. The victims in this case told the police department that once their cars almost collided, they got into a verbal altercation where they exchanged words with each other. After the victims got off of that exit, that Greenbrier exit, the defendant in this case followed. They then went to the victims. They went to the Bank of America location that I mentioned earlier to withdraw money from the ATM. While at that ATM, the victims told the police officers that the defendant in this case got out of the car, shot at them a couple of times, and then got back in the car and drove off. At this time, nobody was hurt. Nobody was shot from those bullets. However, the officers were able to track down the car that the defendant and that driver was in. Eventually, at the time, the defendant was not on the scene, but the officers did get a chance to speak with the defendant in this case, where prior to in the police report states that he admitted to shooting the gun. However, like I said earlier, no one was hit by those bullets. Because of that, Your Honor, the defendant was placed under arrest and charged with the offenses we have in front of us. If I didn't say earlier, this also occurred in Fulton County, but those are the facts of the case.
So, a couple questions. There are 2 counts of criminal trespass, which are basically damage, I'm assuming, to 2 cars?
Yes.
So Mr. McQuwell shot, didn't hit the Watkinses, but I guess hit cars in the parking lot or near the Bank America?
That's correct. It was 2 cars that was present that the bullets went through their cars.
Okay.
I did speak with the victims that owned those cars, and they would like restitution for the damage that was done. They were providing those receipts, but that criminal trespass charge does come from the bullets that were shot by the defendant going into the cars of the other 2 people.
Okay, and there were 3 Watkinses listed in the indictment: Adriana, Asia, and Amana.
Yes, Amana is the child that was sitting in the back seat.
Okay,
So she's the 3rd person that was being shot at.
got it. And you're saying all 3 of them got out of their car and went either to an ATM or into the bank, but it was while they were effectively pedestrians that they got?
I'm sorry.
No, go ahead.
It's my understanding that they pulled up to like a drive-up ATM.
Okay.
The driver got out of the car, and that's when the defendant got out to shoot at them.
Okay, and so you think the facts would show 1 person is out on her feet, the other 2 are still in the car. McQuwell, not the driver of the other car, a passenger, gets out and fires some shots in their direction.
Yes, Judge.
Okay.
We also have video footage from the beauty supply store that's next to the Bank of America store that shows a car circling around, someone getting out and shooting multiple times.
Okay, that car being Ms. Brown's car.
That's correct.
Okay, thank you so much.
Excuse me. That's Mr. McWill's car. I'm sorry.
Judge, hold on a second, please. What were you gonna
We'll
say?
get there. Good morning, Ms. Hardy.
That's my vehicle. That ain't Miss Brown's vehicle.
That's
Good
okay.
morning, Your Honor.
How are you?
Wonderful.
Wonderful. It's a great way to be. Do you have any criminal history information on Mr. McQuwell?
I have I'm showing 3 arrest cycles, but no felony convictions to report at this time.
Thank you.
You're welcome.
All right. Mr. Fortis, I'm happy to hear from you some now. You certainly will have a chance to say more later. It's clear Mr. McQuwell wanted to say something, and maybe it was his car that Ms. Brown was driving, neither here nor there in my mind. It's all about the gun. But I don't want to preclude you from saying something right now. We're not getting into sentencing right now. I didn't even ask the state its recommendation. I'm just seeing, is there a factual basis? Did Mr. McQuwell understand the questions, et cetera, such that there are all the legal requirements for a plea that you are making? It sounds like under Alford and want to be first offender. I'll defer the first offender piece because that's a sentencing piece until we reconvene. But anything you want to add on the procedural front?
I mean, Judge, I'd like to defer because I think it all encompasses into the sentencing. The only thing that I would say that was left out, that I think that the court should consider for the purposes of why we're here today is 2 things or 3 things. Number one, Mr. McQuwell's story would be a little bit different in that while there was an argument going back and forth, Mr. McQuwell, they were going in the same direction. And while they were going into the same direction, the alleged victims in this case continued to follow their car, yelling at them. And actually, when they all got out of the car, the alleged victims in this case picked up a brick, threw the brick through my client's window of the car window. That brick, from my understanding, was turned over to the police. And I do want the court to know that he was not arrested on the scene. He was actually called, I think, by South Fulton or Union APD, and asked about the event. And he was like, hang on, let me just come on down there. They asked him to come down there, and he voluntarily went down there. And at that particular point in time, while he was giving a statement prior to him being represented, he was arrested. So I think that that's a very important point that needs to be told to the court for consideration. Regarding a little bit more in depth of the factual scenario of what happened, that's generically what happened, but I'd like to defer once we get to the sentencing component. But I do think that the state laid out at least a factual basis for that. So no objection on that part.
All right. Mr. McQuwell, do you have any questions so far about what we've been discussing?
No, sir.
Okay. Well, I'm going to accept your guilty plea. I find there is a factual basis for your plea. I guess let me suss out a little bit more the Alford part, or maybe we can defer that as well, because I'm accepting the plea. It doesn't sound like your client is denying that he got out of the car and fired the gun. You're providing, I'm going to call it justification. Explanation, we'll figure out what it is. If it was full justification, you gotta go to trial, but there's certainly extenuating circumstances that I ought to understand as I'm thinking about what an appropriate sentence is. But it doesn't sound like it's Alford in the sense of, I wasn't there, I wasn't the one who did the shooting, I didn't have a gun or anything like that. The facts that, other than maybe what car was where, and not talking about the brick, but the facts, to me, the operative facts of getting out of the car, pulling out a gun and firing the gun, it sounds like Mr. McQuwell is admitting that all those things happened, but context is critical. And you have already begun to put it into more context, and we'll do more of that when we reconvene. So I'm not opposed to Alford, but I need to always understand it. And let's take the criminal trespass. If you fired a gun and the bullets messed up someone's car, that's criminal trespass. I don't know what the Alford part of that is.
Well, as far as the criminal damage part of it, I think the court has a good point, but I think as far as the aggravated assault, was it justification, or was it going to be, us asserting a self-defense argument, and whether it was going to rise to the level legally of a self-defense argument?
Got it.
And I think that after much back and forth, I think that what my client realized is several things. Number one, accepting responsibility, putting this behind him, and moving forward, and not wanting to take, what could be an adverse decision by a jury and that risk.
Right.
So,
jury might not be impressed with you shooting at a car that had a little kid in it.
Exactly.
Okay,
And I think that was the determinative factor, but was there potentially a self-defense argument that could have been made? Sure, but it comes down to the reasonableness standard and do we get there?
okay. Then, Mr. McQuwell, as I said, I find there's a factual basis for your plea. I'll accept it as an offered plea to counts 1 through 4, and then a guilty plea to counts 5 and 6. That's the criminal trespass, the damaging of the 2 other people's cars. Either you had really bad aim or you weren't aiming directly at the car you were shooting at because you hit 2 other cars. That doesn't change anything we're going to do. I don't like to willy-nilly hand out Alford if there actually there are facts to support it. We'll defer the discussion about first offender, but I do find that your plea is knowing, meaning you've understood what we were talking about. And when you didn't, you and Mr. Fortis had a huddle, then you answered the question. I also find that your plea is voluntary, meaning no one is forcing you to enter this plea, but you've decided after consulting with your lawyer that you want to go forward with this plea. Do you agree with that as both knowing and voluntary?
Yes, I agree.
Okay, then that's what we're going to do. Mr. Fortis, can someone in my office sign your name to the indictment indicating the plea in this case?
Yes, Your Honor.
Ms. Smith, can we sign for you?
Yes, Judge.
And Mr. McQuwell, can we sign for you?
Yes, sir.
All right, we'll do that. I think that's all we'll take care of today. Are you still wearing an ankle monitor?
No, sir.
6 months was up, so it came off. Okay, all right. Anything else, Ms. Smith, for now?
Nothing further, thank you.
Do you think you'll have restitution information by next week? It sounds like we're not gonna have trial next week, so it's gonna be easy to find time, consistent with everyone's schedule to get Mr. McQuwell back
Because
in.
I haven't seen that. I haven't seen any restitution.
Right, well, you'd need to, that's why I'm asking. You can't see it if she doesn't have it.
Right.
Yeah,
I'll push to get it.
okay. I mean, I don't mind deferring it. That's normally how it works. I just was curious if we'd be able to wrap it all up. I'm not gonna delay the sentencing for that. We can always revisit a modification of the sentence if Ms. Smith gets paperwork, you look at it and say, this is legit. Look, there's a picture, a bullet went through the door. It cost $400 to fix the door. That's restitution. That need not prevent us from getting to the more essential part, which is what's going to be the sentence for Mr. McQuwell. So I think we're at a close for today. I will have Ms. Nelson work with the 2 of you, Ms. Smith and Mr. Fortis, about scheduling part 2 of this next week. Let Mr. Fortis know your work schedule, because I think I can be pretty flexible.
I'm flexible too. I work for Amazon Flex, so.
Okay, great. Then it'll really be where you have to be and when throughout next week, and we'll find a time.
Next week, the minute I get it, I'll get in touch with Ms. Nelson. I'll copy the DA and then we'll set it down for next week and conclude the matter.
Okay, sounds good. Thank you, everyone.
Yes, sir.
Thank you, Judge. It's good to see you.
Same.
Okay.
Are we able to do Ms. Scott now?
Yes, Your Honor.
Okay, it's just, there's a little kid in the courtroom,
Oh,
so
okay.
if we could knock that one out and get the little kid happily on he or she, his way. All right. Ms. Scott, if you'd come on up, please. Ms. Smith, you're apparently in just the right spot. One second. Before we get on the record, Mr. Hines, I saw that in the Jateric Brown case, there's a need for Mr. Brown to go out of town.
Yes, Your Honor. Actually, since I sent you that email about his grandfather being in a coma, his grandfather has sadly succumbed.
Okay, is there still a need to go for services, celebration of life?
Yes, sir.
Okay, I'll address that. I know I owed you and Ms. Willingham a response on are we modifying the bond? She did get, I saw you were copied on them, letters from the victim's family. So I'd need to process through that. Independent of that decision, I'm very comfortable saying 100% he should, I don't remember where it was out of town that he needed to go. Chicago, that he should go there. If you can just get a window of time, that makes sense. To get up there, be with family, be there for the celebration of life and get back. I will do an order to that effect.
Thank you, Your Honor. I appreciate it. I know Mr. Brown does too.
Okay. But we are here to talk about Ms. Scott's case. So we're going to get on the record. It's position 5 on our trial calendar, 25 SC 004011. Ms. Scott is here with her lawyer, Mr. Hines. Ms. Smith is here for the state. And Ms. Scott, Mr. Hines tells me you're ready to enter a plea. Is that correct?
Yes.
Okay. When you're answering questions, make sure you speak a little more with an outside voice so the court reporter can hear you. And you just move closer to the microphone, which is great. I know we looked for a number of other potential resolutions in your case. People tried and things just weren't quite the right fit. Sometimes it was good news. You're doing a whole lot better than some of the programs. They're treating people in worse situations. So that was sort of happy, sad news. But I know your lawyer worked hard to see if there were other outcomes. But are you ready to go forward?
Yes, sir.
Okay. Ms. Smith will put you under oath in just a moment and ask you a bunch of questions. If at any time you're confused by the questions or you just need to talk with Mr. Hines about what's going on, will you let me know that?
Yes.
Okay. Ms. Smith?
Yes, Judge, thank you. Ms. Scott, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Alexis Tatiana Scott.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Is there any medication that you would normally take that you haven't been given this morning?
No.
How old are you and how far have you gone in school?
I am 30 and I just graduated with my bachelor's degree in psychology in May.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes.
Do you need more time to discuss your case with your attorney?
Yes. No.
No?
Okay.
Well, so the question was, do you need more time? Go outside, talk with your lawyer about the case, or are you good if we keep moving forward?
We're good.
Okay, and it's not, Mr. Hines wouldn't let you be in here if he needed more time. So it's a question whether you are okay going forward.
Yes.
Yes, okay.
And are you satisfied with your attorney's services?
Yes.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
I am.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
I do for the purposes of today.
Ms. Scott, do you remember being arrested on these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
No, we're not.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 5 years probation?
Yes.
Are you aware that the court does not have to accept that recommendation and the court can sentence you to the maximum on each charge and can run those sentences consecutively?
Yes.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that this is a guilty plea that will be permanently recorded on your criminal history?
Yes.
And Your Honor, just not to, sorry to interject, we are hoping to tender this plea under the principles of North Carolina v. Alford.
All right, we'll talk about that with Ms. Scott.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes.
Are you a United States citizen?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes.
Do you understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes.
Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes.
Have you ever pleaded guilty or nolo contendere to, or ever been Have you ever pleaded guilty or nolo contendere to, or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No.
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No.
And has your attorney explained the First Offender Act to you?
Yes.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for each charge in this indictment?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf and remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by pleading guilty to these charges?
I am.
Ms. Scott, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No.
As to indictment number 25 SC 004011, how do you plead to count 1, criminal damage to property in the first degree, and count 2, arson in the first degree?
Guilty. Under offered.
Are you pleading guilty because you have decided that this is in your best interest to do so?
Yes.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you do not have a right to appeal directly from your guilty plea conviction, but if you believe that there's been some type of error, you can apply to the appropriate appellate court to request a discretionary appeal?
Yes.
Do you understand that that process has to be completed within 30 days from today?
Yes.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes.
Thank you, Ms. Scott. Your Honor, if this case were to proceed to trial, the state would show that on July 20th, 2024, officers of the Atlanta Police Department were dispatched to 1011 Northside Drive, Northwest Atlanta, Georgia, apartment 1215, that's also in Fulton County, in reference to a resident breaking items inside of an apartment. To the state's understanding, this was a shared housing building for students that attended Georgia State University, and the person that called was the roommate of Ms. Scott. When the officers got there, they met Kyla Brown, that is one of the roommates of Ms. Brown, and also the person who called 911. When they got there, victim told the officers that Ms. Scott was inside of the apartment breaking items, breaking their personal items, and just kind of blowing up on them. The officers made contact with Ms. Scott when they went into the dorm room or the apartment complex. And at that time, they separated Ms. Scott from the apartment complex. While the officers were doing a search of the apartment, they went into Ms. Scott's room where they saw that a fire had begun. They They don't know what materials were used to start that fire, but it was a fire that had started inside of Miss Scott's apartment after she had been separated from the apartment. At this time, the fire alarm went off, the sprinkler started, and those items that were inside of the apartment were damaged. That first degree criminal damage to property in the first degree kind of comes from the apartment complex and the fact that they had to replace those sprinklers and also replace some of the damage that was made inside of the apartment. At this time, Miss Scott was escorted downstairs by the police. Also, people that were on that hallway were escorted because everyone had to leave. When they got downstairs, they spoke with Miss Scott and eventually arrested her for the charges we have before us. I did speak with the victims. They're not listed as the victims in the indictment, but I talked to her.
Her roommates?
And she told me that, well, I talked to Kayla Brown and she told me that this was an incident that was occurring with Miss Scott where she was just blowing up on them. It was something she had never really encountered before, and she was not seeking restitution at this time. So there's no restitution that the state is asking for. However, those are the facts of the case here. When it comes to the negotiated plea between the state and the defense, we're asking for on count 1, 5 years probation, and for count 2, 5 years probation. For both of those counts to run concurrent and also to be suspended. For the special conditions of probation, the state is recommending for the defendant to stay away from the incident location, to have no contact with the roommates in this case because they're not listed as the victims. So no contact with those roommates, for the defendant to complete an anger management course, and also for the defendant to have a mental health evaluation and treatment if deemed necessary. And that is all from the state, Your Honor.
Okay, did Ms. Brown relay to you at all what she thought was happening? Was Ms. Scott mad at them? Was Ms. Scott just having sort of a nervous breakdown? And it wasn't so much that she says to Ms. Brown, I'm gonna burn you up, it's that I'm upset, or what, how did she describe, you kept saying blowing up at them. And so I was just curious if it was Ms. Scott is mad at her roommates or just Ms. Scott she's having a moment.
It was my understanding after talking with Ms. Brown that it was something separate that had occurred, nothing that they did to her, nothing she did to them, but that she was having, when I say blowing up is because that's what the victim and I talked about.
I believe you.
The language.
Yeah.
But she just had a problem not with them. And when it came to the fire, that was something separate. So she didn't set any of their things on fire. That was something that occurred in her dorm.
Got it. Okay, so they kind of had a suite. Unit 1215 was Ms. Brown and Ms. Scott and.
And it was a third roommate also.
Okay.
So it was three rooms in one apartment.
Okay, if you could email to Ms. Nelson the two names, because you are asking that I require Ms. Scott to stay away from the two roommates, and you've got Ms. Brown, I didn't hear the other name, but if you could get those two names to Ms. Nelson, she'll include them as a part of the condition of probation.
I will.
All right, thank you. Ms. Hardy, any criminal history information for Ms. Scott?
Yes, Your Honor, we're showing 2 arrest cycles, no felony convictions to report at this time.
Thank you. Mr. Hines,
Yes, sir.
what do you want to share with me?
Yes, Your Honor. I have a few requests, sort of minor requests that I've talked over with the state, but as far as Your Honor giving effect to the plea agreement and considering the offered implications. So Ms. Scott was arrested for this case. So this is her second arrest. Her first case, I believe, was a misdemeanor that was dismissed, no arrest. So she has no criminal history, no convictions of any sort. She was arrested for this case July 10th. I'm sorry.
July 20th.
July 20th of 2024 and released on August 14th. She spent that time in the Atlanta City Detention Center, and it was a very harrowing time for her first time in jail, but I also believe a transformative time for her. I was Ms. Scott's public defender back then, and when she was able to bond out after her preliminary hearing, and thereafter her case was indicted, now in private, and she hired me. So I've known her for about 2 years. I've been very, with the whole question of mental health treatment court, as you said, that's like a happy, sad moment because I was glad to hear that she had worked so much on herself, to the extent mental health is sort of out of our hands a little, but to the extent she could work on it and get to a point where those professionals deemed her low risk.
Right.
I commend her for that. Since this incident, and this was a GSU dorm, I agree with Ms. Smith's recitation. She has completed her degree in psychology. She has 2 years of nursing school under her belt, and this case has made it hard for her to complete that. And she's hoping to go back and complete that and get into the nursing field as she always intended. As you know, she had a child late last year, Xavier. He's been at every court date, as has her grandmother, her sister, and her mother. Some combination of them. Her mother couldn't be here today, and her partner, Xavier's father, has been here also to support her. She has a strong support system. So I am in receipt of Ms. Scott's pretty much entire mental health history. Ms. Scott was hospitalized once when she had a mental health break, and this was also a mental health break. My offered concerns are mostly relate to the legality and what a jury would find as far as, the common law definitions of arson and whether this would be criminal damage in the first degree or the second degree, because it was a fire that was created just in Ms. Scott's room. It was on a desk. I believe it was an accident. I believe the evidence would show it was an accident because she was going through a mental break and she was trying to, I believe the evidence would show she was trying to burn pictures and it just got out of hand. You see on the body cam, the officer go in and see the fire on the desk. So those legal concerns and I guess a little bit of factual concern because she was under the influence of a mental break. But she knows, and we talked at length, she knows that, and she wants you to accept this plea because it's in her best interest to not expose herself to a jury's possible finding that she was legally guilty. Ms. Scott is trying to, like I said, get into the nursing field just to find to get into the workforce again, because as Your Honor is, I'm sure Your Honor and Ms. Smith are, know that when there are mental health illnesses at play, one of the biggest things that can help is staying busy and, feeling useful to the community. So I would, we had talked about community service and I'm not, I don't want to step on Ms. Smith's toes, but I'm not sure if anger management for this case would be as helpful to Ms. Scott as community service would be. I just know that Ms. Scott, I've watched her become a mother. I watched her step into that role, and it's really been inspiring to see it. If I do say so myself, I'm very proud of her. She's just trying to work. She's trying to be the best mother she can, and she's trying to take responsibility for what was going on in July 2024, but also put it behind her. So in conclusion, I'm asking, Your Honor, I think that Ms. Smith and I will have a little bit of a difference on the behavioral incentive date. And also I have an order that I often use in these cases of first offender under OCGA 42-8-62.1, subsection B, subsection 1 through 3, sections 1 through 3, to seal her record during the pendency of whatever her behavioral incentive date is. And I just ask you to give effect to the plea, Your Honor. Thank you.
You're welcome. Thank you for that presentation. Ms. Scott, I've got a couple questions for you, and then if there's anything you want to add, I'm happy to hear from you. So it sounds like you just recently got your degree, but it was from Georgia State. You finished up there.
Yes.
Congratulations.
Thank you.
Xavier is how old?
He'll be 6 months this week.
Okay, halfway to his first year.
Yeah.
Does he live with you?
Yes.
Okay, and with whom do you stay?
I stay with his father.
Oh, so the three of you are a household unit?
Mm-hmm.
Okay, and are you in Fulton County?
We're in DeKalb County.
DeKalb County, all right. And next stop for you is nursing school?
Yes, sir.
Do you already have a school in mind?
Yes, sir.
Where's that?
Well, I started at Georgia State, so I was gonna finish
Oh,
there.
just stay there.
Yeah.
Okay, well, good. One of the questions Ms. Smith asked you is whether you take any medication, and you said no.
Well, outside of my mental health medication.
Okay, but I want to stay inside of that. So tell me what medication you take, or really the names don't matter so much as for what are you taking medication?
Yes, so after the incident, actually around the time I got pregnant, I found out I got pregnant in February. So I wanted to make sure that I was in my best mindset before I brought my child into this world. So when I went to the psychiatrist, they diagnosed me with bipolar 2 disorder. So they were trying to understand maybe if the event was a manic episode, or if it was like a depressive episode. So I've been on Zoloft for the depression and then Buspirone for like anxiety. At first they did have me on lorazepam, I think, which is like a mood stabilizer, but it was affecting the baby in the womb, so I stopped taking that one.
Okay. Have you started taking it again, or you're just taking the two that you mentioned?
Just those two.
Okay.
Mhm.
Do you take those in the morning or at night?
One of them I had to take twice. So I take the Zoloft in the morning, and then the anxiety one is twice. So I take it in the morning and in the evening.
Okay. And did you take both of them this morning?
Not this morning.
Okay. Does the fact that you didn't take the medicine make it hard for you to understand what we're doing here?
No, because I'm also pumping, I try to be careful of the medication because it's messing with my lactation. So that's why I haven't taken it.
Okay, and I'm not criticizing you not taking it. That's you're going to manage it in the right way as long as you're taking good care of your mental health. I need to make sure that the fact that you did not take it isn't leaving you overly anxious so you don't understand what's going on or feeling manic or anything like that. Do you feel like you've understood what we've been talking about?
Yes, sir.
Okay. Do you have anything you want to add?
So over the past 2 years, it's been very difficult for me to obtain employment. That's one of the biggest reasons why I went back to school. But however, now that I've graduated, I have student loan debt. And with me not working, even before I had my child, it's caused a little friction in the household. So I think the reason why we've been trying to help to give me employable or community services so that I can kind of get back into the job market. Because, I don't know what tomorrow is going to bring. And I just want to make sure that my son is, that he's taken care of.
Does his father work?
Yes.
What does he do?
He works as a paralegal.
All right.
Yeah.
Household. Well, Ms. Scott, I find there's a factual basis for your plea. I appreciate the points that Mr. Hines has made about some of the legal niceties. I don't mean that in a demeaning way, but there's some questions about legally, was this arson? Legally, was it criminal damage in the first degree? I think a jury could find that it was. I don't know that they would, but because they could, I'll accept the plea with a factual basis. I'll accept it as an Alford plea. I better understand why Mr. Hines pushed back in that way. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to do this, and knowing means that you've understood the things we discussed. Do you agree with that?
Yes, sir.
Okay. Mr. Hines, can someone in my office sign the indictment for you?
Absolutely, Your Honor.
Ms. Smith?
Yes, Judge.
And can we sign the indictment for you, Ms. Scott?
I have a question.
Mhm.
Is it like just 5 years, or can the 5 years
So I'm not there yet. Right now, we're
Okay,
just talking
I'm sorry.
about, do I accept the guilty plea part?
Okay,
And part of that process in the olden days is that the indictment we'd hand around and you'd sign it. It would say guilty, Alford, and Ms. Smith would sign it. We do a lot of that electronically, but I need to have you say on the record, if you're okay with it, that it's okay for us to electronically sign your name to the indictment indicating your guilty plea.
yes, Judge.
That's okay? Great. Now we'll get to sentencing.
Okay.
So I'm going to follow what's been negotiated here, and I'm sentencing you on both counts to 5 years. It's 5 years probation, and they'll run concurrently with each other. So it's a total sentence of 5 years. The special condition number 1 is that you need to stay away from the Catalyst Apartments on North Side. It's where you used to live. Don't go back there. Special condition number 2 is that you should have no contact with either of those roommates. So hopefully you guys hadn't become fast friends, but you guys need to stay apart. Number 3 is that you are going to have another mental health consultation just to confirm the diagnoses. And then if any treatment is recommended by your provider of choice, you got to make sure you maintain that treatment. That could be counseling, it could be medication. But of course, medication you take consistent with your need to keep your kid healthy as well. But it can't be, I'm not taking anything. It just needs to be done in a thoughtful way. And finally, I'm going to have a condition that you complete 60 hours of community service. And those you need to complete within the first 6 months of your probation, not way down the road. I will set a behavioral incentive date of April 24th of 2029. That means that if things have gone well for you, then probation can come to me to say, can we just close this case out? We don't really ever have to meet with Ms. Scott. She's headed in her way, 0 issues with her, and let's end the case early. First offender is appropriate for you. First offender is primarily a benefit. It means that this is not a conviction as long as you stay out of trouble while you are under sentence. That's essential for going back to school because one of the first questions on applications are you a convicted felon? And you might as well throw the application away. Also important with job applications. You don't need to check the box, yes, I am, because you're not. You're what we call a first offender probationer. For you, it's basically going to be a benefit, but you need to understand there's a risk to first offender. If for some reason over the next few years, you get into a situation with Xavier's father or this or that, or you just feel like an episode is coming, that's not a defense to you doing something dangerous to others. If you were to get in trouble again while you're a first offender probationer, and I were to find, because you get a hearing, Mr. Hines could be there for you, et cetera. But if I were to find that you were willfully not taking good care of yourself, or for whatever reason, you just lost it, and I'm making this up, but you hauled off and hit Xavier's dad with a frying pan in the head, not only would you have new charges, but I could take away your first offender status. That turns into a felony, and I could resentence you to both these offenses. I don't see that happening, and I don't say it to scare you, but I need you to understand that there's a risk. And it's a risk for you probably because, if it is a risk for you, it probably would be because you're not taking good care of your medical regimen. But it's out there. I need to make sure you understand that there's a risk to first offender.
Yes, sir.
Okay, understanding the risk and appreciating the benefit, do you want to be sentenced as a first offender?
Yes, sir.
Okay, I'll do that. The last thing, I think, unless Ms. Smith, do you have anything else? Mr. Hines?
Your Honor, I know you've already stated your inclination as far as the bid, but I would ask to be heard because I'm asking for a shorter behavior answer.
Okay, I'm listening.
Yes, Your Honor. So reiterating everything I already said about Ms. Scott's progress and what she said as well, I would just say, as you know, Your Honor, the previous posture of this case was that it would be dismissed after, if accepted, if Ms. Scott was accepted, the case would be dismissed after mental health treatment court. And then after that, the understanding was that it would be, if Ms. Scott was accepted, it would be dismissed after diversion. So I'm asking that we have a behavior incentive date more in line with that instead of 3 years before she can get off, closer to 1 year, Your Honor.
Got it. I appreciate that perspective. I'd probably tether that to more like 18 months to 24 months if I were linking it that way. I'm gonna keep it at 3 years, but I'll tell you this, Ms. Scott, I suspect you'll quickly turn into an unsupervised probationer because you're gonna be just fine. And so there are steps that probation will take as they ratchet back. At first, they're gonna wanna know what's going on in your life. They need to see where you're living, make sure everything's going okay. But if you continue to be no nonsense and no trouble for them, then they'll pivot to, let's just make this you phone in. And then let's just make it, you know what, we're not even supervising you. If you get arrested, we'll learn about it. And those are all good steps to be taking towards then ultimately, let's just terminate it early. So I'm gonna leave it as is, but I appreciate the argument. The last thing we need to do is give you reporting instructions. Because you live in DeKalb, I think you have to report in Conyers. That's where their office is. But Ms. Simpson is going to meet with you outside and give you, she's probably going to need to get a little contact information from you, but she's going to give you a time and place you need to be. Do not miss that intake appointment, because if you're not there, they give you maybe 1 or 2 phone calls and then they just send me a warrant. So make sure you make that appointment. All right? Anything else?
I don't have anything. No.
Good luck with everything.
Thank you.
All right.
Thank you, Your Honor. May I submit that proposed order to seal the record?
You should submit 2 proposed orders. In this case, copying Ms. Smith, the order to seal, and we'll see if she has any objection. And then in the Brown case, the order authorizing out-of-state travel.
Yes, Your Honor, absolutely. And I just wanted to say, thank you to Your Honor. Thank you to Ms. Nelson with her patience and flexibility. I was in trial this week. Expected to be in trial today, but we won on Monday. Big murder.
All right.
I say thank you to Ms. Smith for all your help with negotiations and everything.
You're welcome.
Thank you.
Thank you.
Good luck with everything.
Thank you.
May we be excused.
And happy 1/2 year birthday to Xavier.
Thank you.
Hello, Ms. Wood.
Hello, Judge.
What can we do for you?
There was an add-on 10 a.m.
Yes, Mr. Foster.
and I believe Ms. Willingham is here specifically for that.
Well, we better not keep her waiting.
Because I kept her waiting the other day, all day. and
We did.
Smith missed it.
I know. So let me lay out a schedule so people can plan. We can do the Foster bond hearing. Then I'd like to do Mr. Brown's plea because Ms. Howard actually was here a bunch yesterday just because wires got crossed. And then whoever wants to arm wrestle it, we've got 2, well, I didn't find the kitchens and, is that one where they could take the plea at the same time?
Yeah.
Okay, just like the other one. So I'm gonna let you guys arm wrestle whether it is the kitchens and Turner case or if it is the Browning and Rayborn. But that's the order. So bond hearing, Mr. Brown's case, and then we'll do back to back the two defendant cases. Whew. But Ms. Willingham first, okay? All right.
Thank you. It'll be quick.
That's all right. It gives the deputy something to do too. Can we bring Mr. Foster out? Okay. Something not working?
No, she's not.
Yeah, what was on was the microphone. We were getting this, that was on too. I turned both those off, but all the mics were on it, so it was getting weird feedback.
That's yours to take back.
Okay, let's get on the record. Good morning, Mr. Foster.
Morning.
This is 26 SC 40 81. It is State versus Dwight Foster. Mr. Foster is out here in court with Ms. Wood. The state is represented by Ms. Willingham, who is here. And Mr. Foster, I think all we're talking about right now is bond. We already had your arraignment date. You guys have waived arraignment. You got discovery. I think you were just handed some discovery, which is for you to digest. But Ms. Wood filed a motion for bond a while ago. And this morning is when we're going to hear it. Ms. Wood, when you're ready.
Thank you, Judge. So Mr. Foster has been in custody 113 days. He's currently in no bond status. We're asking for a $15,000 bond on each count. He's 32 years old.
Let me pause you, meaning a $45,000 bond or 15,000 total?
15,000 total.
Okay.
5,000 on each count. Thank you. He's 32. He has an 11th grade education. He's been here in Atlanta for 3 years. He's originally from Tennessee. His mother and his brother live there. They are supportive from a distance. He is already linked up with the Grady Act team, Judge. He has housing through there. He also gets his medications through Tin Park Place. His mom and his brother, and he has also shared with me, they're a little concerned about him losing that housing spot the longer he sits in custody. So that is.
Meaning he had Grady Act housing before he was arrested?
Yes.
Got it.
Yes. And so I reached out to them to see what the actual date is that he might lose it. I haven't heard back yet. Ms. Ross has also been plugged in. But that's the reason that we're asking the court for a bond in this case. And we've also submitted a referral pad as a backup option. We just don't have an answer on that yet.
Okay. You are comfortable that Mr. Foster's on the right docket and we don't need to have any work done to see. I'm just looking at count 3 of the indictment and so make sure Mr. Foster is well enough for us to be having all these conversations.
Right now, yes, Judge, and Ms. Ross has been working with him very closely.
Good.
And I will go ahead and let you know, Ms. Willingham and I are already working towards a resolution. There's just a couple of things that we need to square away before we get there. So that's really the only reason we're asking for a bond today as well, other than a fee.
Okay. Can you tell me if you know who Ms. Gaffney is to Mr. Foster?
Ex-romantic partner.
Okay. Understood. So total $15,000 bond. You believe he's got housing still through ACT, and so he would have services really all around him in the ways that he ought to be supported while then the case moves forward.
Yes, sir.
Okay. And what are the source of resources to even post a bond would be family? Okay. Got it. Ms. Willingham.
Yes, Your Honor. The state would be objecting to bond at this time. Starting with Mr. Foster's criminal history, he received first offender for a robbery in September of 23, which he was on probation for. That has been revoked already. That was handled in January of this year. But he actually should not have even gotten first offender because he had a felony, a theft of property felony from 2019 out of Tennessee. He also, since the robbery that he was on probation for, obviously he picked up this case. He also picked up a criminal trespass in November of 24 and a willful obstruction in December of 25. Prior to coming to Georgia in 2013, he had an unlawful possession of a weapon. In 2014, he had a theft. And in 2016, he had an evading arrest. And then the 2019 theft of property that I previously mentioned. So we would obviously have some concerns about his risk to reoffend. He's picked up several charges while being on probation for a robbery that was originally charged as an armed robbery. And then, Your Honor, in this incident, I have spoken with Ms. Gaffney, and she's very much afraid of the defendant. She actually does not want to appear. She didn't appear today virtually or in person because she's afraid of actually seeing him. She's relocated at this time, Your Honor, so I won't necessarily say that there's a risk for him to find her because he doesn't know where she's at. But we also know that in cases like this, that's not always a
sure thing. So we would have a strong concern for primarily the defendant's risk to reoffend. And that would be the reason that we believe this case should stay in no bond status.
All right. Give me 1 second while I look something up. Okay. Ms. Hardy, how many cycles do you have for, I don't know if you got the Foster calendar. Do you have his information?
I do.
Okay, of course you do. How many cycles?
There's 15 total, 3 arrests out of Georgia and 12 out of Tennessee.
Okay, thank you. And Ms. Willingham, you were saying that Mr. Foster was on, you're saying it shouldn't have been first offender, whatever it was, probation for the robbery when this happened. And as a result of this arrest, he's been revoked.
Yes, Your Honor.
Does that probation continue or was it closed out by way of, I'll ask Ms. Simpson, she's got better visibility into that. So what happened?
He is still on probation, Judge.
Okay, the revocation wasn't 8 years and so bond doesn't make sense.
Yeah, Judge Richardson, only revoked 4 months and reinstated the balance.
Okay.
So he does retain his first offender status.
He's on active first offender probation now. Okay, got it. And we wouldn't need to worry about a revocation in this case because Judge Richardson already dealt with it. Okay. So one last question, Ms. Willingham, then I'll get back to Ms. Wood. Ms. Wood said the two of you have been in active discussions about resolving this. If in the end, this is being resolved in a way where Mr. Foster is back in the community, we need to be comfortable that there's a support system in place. And so the tension I'm feeling, I share your concerns. Everything you've described makes me worry about bond. But someday Mr. Foster gets out. This is not a case where you're going to recommend 10 years, but I'm going to give 10 years. Other than maybe the cat part. Then Mr. Foster's going to be out. And it would be tough if he lost a set of supports that were in place. Although if they were in place when this happened, I don't know how supportive those supports were. So I'm curious on your thoughts on that.
Judge,
It may just not be your problem.
I was gonna say, although I do recognize that, you know, considering some of what it appears to be Mr. Foster's history, there will need to be support. Not my dog, not my fight.
Got it. That's something to consider at the time this is being sorted out.
Yes.
Okay. All right. I appreciate that perspective. Ms. Wood, back to you as the movant. If there's anything you want to add.
I don't think I have anything to add at this time, Judge.
Okay. Mr. Foster, have you followed what we've been discussing? Pretty much?
Fraction.
Okay. Do you have any questions about anything that we've been talking about? It's okay if you don't have questions. I just want to make sure if you do, I see if I can answer them.
I mean, I probably do, but I don't know if they might be the right appropriate ones.
Okay, well, I'll tell you what, you should ask them of Ms. Wood. There are no wrong questions, especially for your lawyer. So I'll let her talk with you a little bit and see if she can answer your questions. If she says, you know what, those are good questions for the judge, we can always get you back in here and do that. I'm going to deny the motion and rely on your lawyer and the prosecutor to continue working on an overall resolution for your case. These are pretty serious allegations. They're only allegations. It's not proof you did anything, but you were on probation for a kind of serious charge too. And I am deciding that you ought to stay put until we can get to the bottom of what this situation was with Ms. Gaffney and the cat and all that. Okay?
Yeah, I got a question. Because
Only about bond, remember? It's
Oh,
not
no,
about
no.
guilt or innocence.
Yeah, like I said, these are only accusations. I'm not deciding that you did anything, but what I do have in front of me is a little bit of the history where you either admitted you did something or a jury said you did something. And based on that, I'm gonna leave things as they are. But that manila envelope is a real good sign. That means your case is moving along quickly. And that Ms. Wood is working with the prosecutor to see, is this something that needs to go to trial? Let's get you in here and do the trial. Or is it something that can work out? In which case we'll get you in here for that plea and start structuring a setup for you so that when you get out, something like this is less likely to happen. Okay? Thank you.
Thank you, Judge.
You're welcome. Thanks for coming by, Ms. Willingham.
Problem, Judge?
All right, we are going to do Mr. Brown's plea now. Is everything else yours, Ms. Smith? Yes. All right. Or you can just sort of set up shop.
Just a chance to compare I sent you.
I'm getting it right now.
Okay, I can summarize it.
Okay, but I can also read it. There'll be a window for me to do that.
Nah.
Let me know when you're ready.
Ready, Judge.
Ready. All right. We are getting on the record with position 21. It's 25 SC 005 798, State versus Tyrus Brown. Mr. Brown is here in court with Ms. Rios. State is represented by Ms. Smith. And we are going to move forward with a plea. Mr. Brown, you've now been in court for a little while, and so you understand, I think, a little bit about the flow. Ms. Smith will swear you in, ask you a bunch of questions about you and your case and your rights. You need to answer those truthfully and completely. You also should let your lawyer or me know if at any point you've got a question. Will you do that?
Yes, sir.
Excellent. Let's get started.
Judge, before we start, would you like to know about the reduction in this case?
Always.
Count will be reduced to battery. That's OCGA 16-5-23.1.
All right. So we're moving forward with a misdemeanor.
Yes. Mr. Brown, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Tyrus Rashard Brown.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you would normally take that you haven't been given today?
No, ma'am.
How old are you and how far have you gone in school?
36, master's degree.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, I understand.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, I did.
Do you need more time to discuss your case with your attorney?
No, ma'am.
And are you satisfied with her services?
Absolutely.
Counsel, are you satisfied that your client has a full understanding of this proceeding? Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
Yes.
Mr. Brown, do you remember being arrested on these charges?
Yes, I do.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
No, ma'am.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 12 months probation?
Yes.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on this charge?
Yes, I do.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes.
Do you also understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes.
Do you understand that if you're currently on probation or parole, that your probation or parole may be revoked based on you entering a guilty plea today?
Yes, I understand.
Are you a United States citizen?
Yes, ma'am.
Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes.
Have you ever pleaded nolo contendere or guilty or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No, I haven't, ma'am.
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No, I haven't.
Has your lawyer explained what the First Offender Act is to you?
She did.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on probation, your first offender status could be revoked, you could be adjudicated guilty, and you can be resentenced up to the maximum sentence for this charge in this indictment?
Yes, I understand.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this plea of guilty?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by entering this guilty plea? Mr. Brown, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea today?
No, ma'am.
As to indictment number 25 SC 005798, how do you plead to the reduced count of battery for count one?
Guilty on the effort.
Are you pleading guilty because you have decided that it is in your best interest to do so?
Of course.
Are you aware that even if you do not admit guilt, this is a guilty plea and places you in the same position as if you were convicted by a jury at a trial?
Yes, ma'am.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you do not have a direct right to appeal from your guilty plea conviction? But if you believe that there's some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
I understand.
Do you understand that that process has to be completed within 30 days from today?
Yes.
Do you understand that you have only 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes, ma'am.
Okay, thank you, Mr. Brown. Your Honor, if this case were to proceed to trial, the facts would show that on June 2nd, 2024, one officer, Officer Chandler of the Atlanta Police Department, was dispatched to 3478 Lakeside Drive, Northeast Atlanta, Georgia. That's also in Fulton County. When the officer got there, he spoke with the courtesy officer that was on duty, Officer Jeff. Security Officer Jeff told the officer that Miss Mariah Howard, who is the victim in this case, she came down from Mr. Brown's apartment on an elevator. She was crying, her eye was bruised, and she was asking for help. In this case, the security guard called EMS and the police to the scene. When the officers got there, they got a chance to speak with Miss Howard, and she told them that she came over to Mr. Brown's apartment around 10 p.m. that night to visit him. She also stated that she came over to do some laundry. I believe she was in town, and where she was, something with the city was happening, so she couldn't watch where she was. So Mr. Brown allowed her to come over to wash those clothes. When she got there, she stated that they were conversing, they were having conversations, and that she eventually gave Mr. Brown a hand massage. Once she gave him a hand massage, Mr. Brown then asked for sexual intercourse. When she refused, Ms. Howard stated that when she refused, Mr. Brown in this case started hitting her in the face, causing that bruising to her eye. At this time, Ms. Howard was being seen by EMS Grady, where she was later transported and treated for the injuries to her eye. Mr. Brown the officers then went up to Mr. Brown's apartment, where he told the officers that Ms. Howard came over. They had met on Instagram a few weeks prior. So when she came over, they were drinking, smoking, and they had sexual intercourse. He showed the officer a video that was evidence of the sexual intercourse. He stated that when Ms. Brown came over, they had a few drinks. She became belligerent and loud in his home. At that time, Mr. Brown asked Ms. Howard to leave. She refused, and then Mr. Brown stated that she had just did something else with his friends a couple of weeks ago, kind of telling her about something that he knew at that time. He stated Ms. Howard got mad at him saying that and started to hit him. And in response, he defended himself, but that defense caused the bruise to Ms. Howard's eye. When she went to the doctor, they were able to assess that bruised eye. They saw that she had damage to her cornea, so her eye, she was hit and bruised pretty serious. At the time, on that day, Mr. Brown was not taken into custody. A few days later, I believe like a day or so, Ms. Howard went to the Atlanta Police Department headquarters, told them about what happened. The detective that she was speaking to then at that point took out warrants for Mr. Brown. He was taken into custody a couple of days after that, where he was charged initially with aggravated battery. Again, this happened in Fulton County. Regarding the negotiated plea between the state and defense, we've agreed to a reduction to battery for 12 months probation, for special conditions to be for the defendant to complete an anger management course, for him to pay restitution to the victim for her medical bill and expenses. I do have all of those receipts. I have to send them over to Ms. Rios. However, that's estimated at about $4,000. So we would just like to have that restitution hearing as soon as possible, since the probation in this case will probably only be 12 months. The state is also asking for the defendant to stay away from the victim in this case, and also to complete 30 hours of community service. It's my understanding that the defendant is taking his plea under first offender, so we won't be asking for a bid date or anything like that, but just making that note. Regarding the reduction in this case, because it is injuries that the victim got in this case, and I've talked to the victim multiple times about how this process works and kind of the reason why we were reducing it. The main reason why we were reducing it was because unfortunately there was some inconsistencies in the original story that was told by Ms. Howard on what happened, if she had anything to drink, and kind of the relationship between her and Mr. Brown. From the evidence that we have and looking at the totality of the circumstances, the state did not feel like proceeding on the aggravated battery or hence going to trial would be successful based on those inconsistencies. I did talk about that reduction to Ms. Howard and also to her mom, Ms. Foster. They are not happy with the reduction. They disagree, rightfully so. I understand that. But I did explain to her the reason why we were reducing the charges in this case and the weaknesses that the state kind of had that would make it harder for us when we went to trial. But she is here today. She's present. She's been here at every court date, and she would like to be heard today. That's
Okay.
all from the state, Your Honor.
Got it. Thank you for sharing all that. Ms. Hardy, do you have any criminal history information on Mr. Brown?
We're showing 2 arrest cycles, no felony convictions.
Can you tell me about those 2 cycles?
Yes, let me pull those up. Okay, in December of 2021, there was an arrest for a fray, but it was no pros. And then the other one is this case that's on the calendar.
Got it. Thank you so much.
You're welcome.
Ms. Rios, before I hear from Ms. Howard, there's something you need to say?
Well, it was part of the negotiation was also that it terminated after he completes all the conditions.
That's correct.
Okay. Meaning if after anger management, after the community service, then he could apply to have the sentence terminated.
Yes, we did. The only portion of this, we'll talk about that later, is that we're asking for no community service, and we'll explain why, but the anger management and the payment of the restitution.
Okay. I'm not including the restitution yet unless you don't dispute the dollar amount. I thought that you hadn't received the paperwork.
We haven't received proof, but we're
Got it.
anticipating that if there's proof, we would have no problem.
Got it. Okay. And then that would become a condition, and payment of that would be something that would have to happen before I'd consider early termination.
Yes, sir.
That makes a ton of sense. Ms. Howard, hey, it's good to see you again. I'm going to ask you to come on up and sit in the middle seat at that table there. Is there anyone from your office who can sit with her, or do you want to? Great. Okay. Good, good, good. Good morning, Ms. Howard.
Good morning, Judge.
I appreciate you being here again, and I would very much like to hear from you about this case, how it's affected you, and your thoughts about what should happen.
Thank you. Your Honor, I am tired. I have been coming up here for the past 2 years. And just a little bit about the case. I wrote some stuff down. I was attacked by Tyrus Brown, who is the defendant, in June of 2024. And I have followed procedure to file a police report. You know, they came, that was mentioned. And I did leave with the ambulance, where I suffered from a orbital fracture, which has caused me to have flutters in my eyes, which I will forever have. Those are reoccurring black dots in your eyes where you, see things. And so I have to have corrective lenses. And I've been seeing multiple eye doctors about that. The investigators determined that Tyrus did wrongfully assault me, and he was arrested and given 2 charges. I have tried to seek a restraining order because I did not feel safe here, living in Georgia by myself. And so I relocated temporarily with family in Alabama. And from that point, trying to get a restraining order, I reached out to the Victim Advocates Program, and I was given an advocate who did not make any contact with me. I texted her, I called, I left messages with the office, just about my hearing, but just about his hearings, because I would like to attend. No response from anyone. Going forward, the only reason I really have knowledge of everything now because of this year, I've been speaking with Ms. Smith, and outside of doing my own investigation where I've talked to lawyers and they've gave me information about court dates. The district attorney office is proceeding against Mr. Brown, and now they have dropped the 2 charges down to 1. And Ms. Smith did express to me her reasoning because he felt that before she dropped it to a misdemeanor, it was a felony. And she expressed to me that she felt that it would stick and be more beneficial for my case. But as of this month, April, moving forward, it has dropped to a misdemeanor. And that has changed our entire plea agreement, which I just find as injustice for me. We had agreed on the terms of a 10-year probation period, the mental classes restitution, no contact. And now it's just the new terms are a misdemeanor and the same things as far as the no contact, the restitution, and the classes. I just feel like there's no due process on my behalf, and I feel like I am being discriminated against on my gender and my nationality. I just strongly believe that there's just a lot of misconduct with my case. Mr. Brown has been arrested for fighting back in 2023, and like I said, I have permanent damage to my eyes. And not only that, I have physically and mentally changed. I have attended therapy for the past 2 years, given to me by Grady. That's a free program that they offer. And sometimes I was not given transportation, so I had to provide those on my own. And like I said, I had relocated to Alabama. I'm from Mobile, which is about 6 hours away. So I'm driving back and forth. Sometimes I'm being told that the case is being, he hasn't taken a plea, or that date was changed for him to take a plea. So I'm just coming up here and I'm not getting anything. I just want to mention, sorry, I wrote this here. Mr. Brown has taken part of my life that I will never get back as far as my vision. I have come to terms that everyone cannot stand strong or understand the power of discernment, but we are here today because a man cannot accept rejection. Okay. When you have done something wrong, usually you are disciplined. In this case, I feel like this is injustice. You know, this is the state versus him, but this is him versus me because I am defending myself. I have made so many trips to Georgia and with no results. I feel like there has been a lack of care or concern for my case, and this is heartbreaking. How does one cause physical harm to someone and allow to use their first offenders? I don't believe he should be given that option as he is fully aware of his actions, whether he says it or not. And there has been many conspiracies against women, and this will never end. You know, because things have been said as far as inconsistencies, whether I said that, you know, I may have said things to Mr. Brown, the reason why he attacked me. But from my understanding, I have never met Mr. Brown up until that day. And when I talked to Detective Scott, she has every message from the time leading up to me meeting Mr. Brown. So he has never met me, but he planned to meet me. And yes, there was someone had hit a power line. So I believe the water was off in the city. So I did ask him when I made plans to meet him if I could wash my clothes there. So that's what resulted in me having items and being there. And Mr. Brown failed to have discernment because I did. I knew that I did not want to have any physical interactions with him that night. And so, yes, Mr. Brown has a conspiracy against me. He may know someone I have had relations with in the past, so he assumes that because I have done things with another man that he has that right. You do not have that right. And, you know, if you guys decide that, you know, you want to keep the misdemeanor, there's nothing I can do about it. But I believe every dog has their day. And Tyrus, you will have your day. And that's all I have to say.
All right, Ms. Howard, I appreciate you sharing that. I had no idea you were commuting all the way from Mobile to get here. But that shows me that you are very committed to what you think justice is. Tell me what you think justice would be in this case.
Well, I believe when we first talked about his sentencing, it was 10 years probation. And I think that was the maximum amount that he could receive. And I do believe that he should still be given that. He should not be offered a first offenders because there was 2 charges. Whether or not he has other convictions in his past or other arrests in his past and weren't convicted, if we would have kept those 2 charges, I feel like he would not be allowed the first offenders because APD investigated and they felt that he did wrongfully assault me. So if he was given 2 charges, why are we offering him a misdemeanor? I asked for those charges to be brought back. Well, that 1 charge, so we would have 2.
Got it. Okay. Well, I appreciate you sharing that and you standing up for yourself. That's not easy to do. You're brave and you're persistent. And I hope those traits help you as you try to move forward in Mobile.
Well, I am relocating back here.
Wherever you choose to move forward. Mm-hmm. Okay. Well, we welcome you back to the Atlanta area. Are you back now or you will be?
I'm back.
Okay, good. Well, I'm glad you're back and I hope you're finding your footing. And like I said, I appreciate you sharing what you shared. It's important that I hear from everyone who was involved.
Thank you.
You're welcome. Ms. Rios.
I'm not sure how far you were able to get into what letter.
Read the whole thing.
Okay. Well, just to reiterate, he has a 9-year-old son that he's taking care of. He actually put himself on child support. He sees his son often. His son lives in Memphis, but he flies him out to see him, or he goes to see him. That's where he's originally from. He struggled a lot growing up there, helping his mom, who has since passed, dropping out of school to help her. Getting his GED, then going to community college, then university, then getting his master's degree. So he's worked really, really hard to be able to provide a good life for his 9-year-old son, so he can be a good example for his child. So he's also self-employed. He works as an independent construction worker, independent insurance agent, and he's been trying to get government opportunities, but because of this on his record, he hasn't been able to do that. That's why we were asking for it to be under a first offender. I know it's not usual to do that for a misdemeanor, but for in his case, going 36 years without having any convictions, misdemeanor or felony, it makes sense for him. And also to see, we're asking for it to be sealed on the front end, so this will not affect his ability to keep being able to obtain jobs, because he said they've done background checks and this has been really difficult. Now he's accepting responsibility for what happened as far as him letting someone come over to his house that he barely knew, them having an altercation. He still maintains that she attacked him and he was trying to defend himself. It was a thing where she's hitting, he's flailing his arms, and yet the injuries were there. We're not disputing that she had injuries. He's saying that he doesn't go around hitting women. This is not of his nature. He understands that he had responsibility about putting himself in that position. It is under Alford because he thinks that he didn't try, it was in self-defense, he didn't try to hurt, it wasn't malicious, but he understands that he should never have been in this situation in the first place. I saw the evidence in the videos, and they initially did not arrest him because they were like, it's too much going on here. Officer said on the camera, her story doesn't completely make sense. They said something obviously happened, but it's too much to figure out right now. She gave multiple different stories and it just was confusing to the officers. He was actually he called 911. And so I heard the video of them 911 calling him and asking him if he went to press charges against her. And he said, no, I just want to move on. And he thought that the situation was just done and everyone was moving on from that awful night. So I've talked to Mr. Brown numerous times about it, because initially he's like, I want my day in court, I want to have a trial. I don't want this to be like known as I'm hitting women because I didn't do this. But as going back and talking with the state, he agreed that this is the best option to avoid trial, because you never know what a jury is going to do. And the injuries, there was an injury. So that's why we're asking for it under Alford. He has no problem paying the medical bills if there's proof of that. He just wants to move on with his life. And so the only portion that was not negotiated was the community service. And he's saying that because he was between the contracts and between him seeing his son who lives in a different state, he doesn't be in the anger management. He doesn't believe he'll be able to do all that within the 12 months period, or it would be too much for him, if that's what you're saying. So I'm hoping that we cannot do the community service and we can do the anger management. And honestly, initially, when I was taking him, when I showed him, I actually sent him the offer. We forgot to put that in the email, so he agreed to everything. And then later, I mentioned the community service, but that wasn't a part of what I relayed to him. So I understand why he was like, wait, whoa. So I'm hoping that we can do it under first offender, Alford plea, with the anger management, restitution, and terminate after that is all completed.
All right. Ms. Smith made reference to there being some type of video evidence that there was intimate contact between the two. I don't want any details, but I'm curious if you agree with that, if that was news to you. But you heard that there was one, or was it the first time you heard of it when Ms. Smith just said that?
That was on the body camera.
The detective, the police filmed something happening?
No. They showed them. They asked.
So Mr. Brown said, let me show you some proof of my version of events.
Yes.
And played something that may have been on body cam.
Yes, Your Honor, because he only did that because she was saying that.
I understand why he did it. People sort of glided past that, but that to me is, I'll call it physical evidence of an inconsistency in the versions of events. I don't need to see the video, but if it was more than a hand massage, then that's different. That's a different version. Okay. All right. Mr. Brown, I've read your letter. It was very well written. You have overcome a lot. You're also in this situation. And as a result of this situation, Ms. Howard was pretty seriously injured with what's leaving her with some permanent conditions. Is there anything you want to add beyond what was in your letter and what Ms. Rios has said on your behalf? You don't have to add anything at all, but I need to give you that opportunity so you can't say later on, well, I didn't get to tell the judge X.
I'm gonna just leave it in God's hands. I know what happened, and I'm gonna just let God do his thing.
Okay. That'll happen a little later. I'm going to do my thing now.
I guess.
But Mr. Brown, I do find there's a factual basis for your plea. This would have been a messy trial for the state and for the defense. It would have been all over the place for the jury. They would have been confronted by a very, someone who would, I think, arouse compassion from the jury with Ms. Howard's presentation of what she's been through. If you chose to testify, I think they'd also understand that it was more complicated than it might seem on the surface. And so I understand why two things are happening. One, that the state is going with really what was the second charge. I do want to address one thing Ms. Howard brought up, this notion that somehow it wouldn't be first offender eligible if there were still two charges. You were originally arrested for battery and aggravated battery. The state went forward with just one of those charges, aggravated battery, and here we are back to one of the things you were originally arrested for. Had the state indicted you for both, you still could have been eligible for first offender. It has not to do with the number of charges, but whether you've ever been convicted of anything before. And you were arrested for something before, back in 21, that was dismissed by a different office at a different time. And so you are 100% eligible for first offender. And I want Ms. Howard not to think that some decision Ms. Smith has made about changing the charges suddenly makes you eligible. You could have had 100 charges and pled to all 100 charges today, and you'd still be eligible for first offender. It doesn't have to do with number of charges. It has to do with whether you've ever been convicted before, and you haven't. So I think first offender is appropriate. I am glad to hear that Ms. Howard is back in the community she wants to be in, and that she continues to get counseling. I think that's important. And I appreciate her desire just to move on, but also to be acknowledged that she endured something and went through something, whatever that something was. I wasn't there for it. I also appreciate, Mr. Brown, your devotion to your son. I have sons, and they are very important in my life. And you are moving mountains to be present, even though just because of the relationship you have with his mom, you got physically present all the time. I think that's a good thing that you're doing. I'm accepting your plea. As I said, I found there's a factual basis for it. I also find that your plea is knowing and voluntary, meaning you've understood what we've discussed. And while you are not enthusiastic about it, you are deciding of your own free will to go forward with this plea. Is that a fair statement?
Yes, sir.
Okay, then I'll accept it. Ms. Smith, can someone in my office sign the indictment for you? Yes, sir. Ms. Rios? Yes, sir. And Mr. Brown, can we electronically sign your name indicating your offered plea to the reduced charge of battery?
Yes, sir.
So we're back really where we started with what the police arrested you for. Mr. Brown, I'm going to sentence you to 12 months to serve 1 month with a balance on probation. You'll get credit for the month you've already served. You're not going back into custody, but you will have 11 months probation. Special condition number 1, no contact with Ms. Howard.
Yes,
Don't
sir.
write her, don't text her. Insofar as you have shared connections, don't use those shared connections to get word to Ms. Howard. Whether it's a word of outreach, I'm so sorry, or it's a word of how dare you say something like you said. If she brings evidence to the state and the state brings it to me that you were trying to interact with her in any way or using someone else to interact with her, that's going to be the quickest way to have your probation turn into custodial time. Understand?
Yes, sir.
Special condition number 2, you'll complete an anger management course. You need to do that within the first 4 months of your probation. I am going to impose the community service. It's only 30 hours. You have 11 months in which to do it. That's about 3 hours a month. And I read your letter. I know you're busy. You're going to be able to take care of that. I'm not saying anything about restitution yet because Ms. Smith needs to get that paperwork to Ms. Rios so that the two of you can look at it, confirm that it relates to care that Ms. Howard has been receiving for her eye injury and counseling related to all that. If it does, it's likely that I would say that's restitution, and it sounds like you're prepared to pay it. As soon as you complete anger management and the community service, and if there is restitution, you pay off that restitution, I am open to consider having your probation become unsupervised. So you're under the sentence, but you're not needing to check in with the folks from probation. I don't think they're going to have an issue with you going to Memphis, but you should check with them first. And if they need a green light from me for you to go to Memphis to see your son, you have that green light. But you just need to understand the dynamic may be that you call probation to say, I'm going to Memphis next weekend, going to visit my child, or next week, or however long the trip is. You just may need to get that green light in advance. They may say, because it's a parental visit, don't worry about telling us. But do check with them before you make plans to leave the state of Georgia.
Yes, sir.
And follow whatever their rules are. And if their rules are they have to check with me, I'm letting you know in advance. You're not going to get a no from me if it's a trip to Memphis. A trip to Vegas is something different. I need to understand why, but I get why you're going to Memphis.
Appreciate
Okay?
it. Thank you.
Ms. Smith, anything else from the state?
Nothing further, thank you.
Anything from you, Ms. Rios? All right, Ms. Howard, again, I want to thank you for being as present as you were in this case and sharing with me what you've gone through. And Mr. Brown, keep doing what you need to do for your son, okay?
Appreciate you, Honor.
Thank you.
This one, Judge, we are ready on Mr. Charlie.
Okay, good to know. We're actually going to take a quick break so our court reporter can get a break. If she were here in person, she would have thrown something at me by now.
Absolutely.
So we'll do that. And when we come back, we will handle the Turner and Kitchens plea. And immediately after that, we will handle the Browning and Rayborn pleas. Okay?
Thank you, Judge.
You're welcome, Ms. Rivers.
Oh, we're still sharing.
Yes, you talk to Deputy Gordon. I'll be back.
He just looks so nice today. I can't compete.
He could lend you the necklace.
Oh my God.
Soon as he takes over the probation.
Are you serious? To who? Princeton. Oh, you should. Oh my gosh. This is professional. Oh, wow. Was it Kristen? Oh my gosh. I think doing pretty good on the go there. He walked over and I looked at him. I was like, dude. That's so funny. It's not awkward. Oh, I'm trying to. I mean, you gotta have the flair though. Yeah. Keep up. I think he's in pretty, it's flairish. Gotta get the monogram cufflinks. He don't. And the chain. He don't go there next time. I'm gonna upgrade a little bit. Yes. Like, I'm gonna upgrade you just a little bit. Well, gotta get a hat. Let's see. I thought you were gonna tell me he was filming in the hallway, like in a video. No. What's that, Mom?
Okay, make sure, yeah, they're gonna contact you. And then with that, I'm gonna send you the petition for restitution. And then, something about that to you. Again, once you're done with everything, let me know, so I need like a judge.
I got a quick question.
I'm sure you. The only thing is that accident.
Oh my gosh, he is such a hoot. That is hilarious.
I got you.
Yeah, so let's wait a minute.
I got you.
Yes.
Thank you.
I missed that.
Me too, and thank you, I'll make sure.
That is funny. You always have such pretty pens. I like pretty things. I like it.
What's today's date?
Oh, I don't like that ring.
Oh, thank you.
The 23rd. Yeah.
Yeah, I like pink stuff. You know what? I used to lie that my favorite color wasn't pink because it felt so
Why?
girly. But now who cares?
Now you can embrace
It is
that.
my favorite color.
Yes.
Well, purple. They're neck and neck, pink and purple. But I like light purple. Like I like lilac.
Oh, like that color of that shirt the other day?
What shirt?
The girl. What day was that? The girlfriend shirt. Remember?
Yes,
I don't
that
remember
color.
what
I
day
love
that
that
was.
color. That's why I like the outfit. I love that. Like the
Mm.
lighter purple, the darker purples look good on me, but as far as like pink colors that make me happy.
Have you ever
it's
had
a
your
lighter
colors
color.
done? to see-
No.
Oh, I've not done it either, but I want
I
to.
need to do that to figure out if you're like a summer, autumn, or
Yeah,
spring.
yeah.
I don't know.
There's a thing on the internet.
I need to figure that out.
Yeah, well, like I think you like submit like a photo and it does
Oh,
like
you
an
put it-
AI
oh.
like rendering or something. Yeah, yeah.
I'm gonna do that.
They tell me anything when it
I'm pretty sure. I don't think purple is an option. Well, maybe. I guess. I don't know.
Purple has been my favorite color since I was like 5.
Oh yeah.
My godmother made my first dress with my name on it.
Oh my god.
Oh.
Oh my gosh.
It's been my favorite color ever since.
That's so cute.
Have you ever tried like purple blush? It actually looks really good.
I have purple lipsticks.
I haven't tried purple lipstick. How's that
I don't think I've
look?
ever seen purple blush.
It's like a subtle. It's like almost kind of like a plumish, but it's still like it gives like purple and it looks really nice. I've tried it before. I'd like to wear it in the fall.
Oh yeah.
How to pair them with my complexion.
With
Right.
what?
Blushes.
Oh,
I'm so terrified.
really?
Because I don't know how to pair them.
Just get like berries and like darker pinks. Because I wear berries and darker pinks. I'm a little darker than you, but it's still like that's all you do. But thank you. If you just wear the same colors, it will look great on you too. Just stay away from the light pinks because it makes black people look ashy.
Do you use powder or cream?
Cream. I don't like powder.
I was about to say I feel like powder's like really to work with.
I like cream foundations and cream, like
Yes, yeah, I
everything.
use cream
Yeah,
foundation.
powder does make you look great. All the powders make you look great.
I even tried a powder, but I just don't like. I don't.
They do.
It looks cakey.
It looks cakey, and you look like a corpse. It looks like people who did the
If I mess around and just sweat just a little bit.
Yeah.
Pieces will just
Oh yeah.
yeah. No, don't. The cream is.
Who? Oh.
I got a walk-in for a set aside.
Oh, yeah.
Well, I think he's gonna set aside because he was in a program this whole time. You know, Judge loves like trust programs, so that's why he was like there for 18 months and didn't know about his court date. His bonds person here too. So I'm gonna ask to do that.
I said, Josh, the amended for Mr. Mass.
Why did that happen? Is it the same thing? The same thing. Man, can you talk to him? Because I felt so bad since our Maxie was in there. I went back and I said, calm down. I went back and looked at us. I was so mad because his uncle or someone called me and I was like, dude, I forgot to check that he was still in. Yeah.
Like he's off probation.
Yeah. And so when I saw your
He's still in custody?
Right. So when I went and pulled up, they don't say. What? Can the jail stop? Like, we need to talk to him about this.
Yeah, I might have to.
Because I meant to Joe check to make sure he's out and I forgot. I need to be checking every single one I have to do.
I haven't gotten the order back yet from the yesterday.
Did he sign it?
From Tuesday. I haven't gotten anything.
Okay.
Mr. Moses.
Did he sign Massey's?
Anyways, I said that he's yet. I haven't gotten it Mr. Moses back yet.
Oh yeah, because Miss Moses, his mentor just texted me and was like, he's Mosley still in. They sent him back to me in Sydney. So Mosley still. Yeah, he's in Unity because I think I don't know why he's in Unity, but yeah, they said the jail they called the jail hasn't got the lawyer yet. We need that, and Mr. Matthew need to be expedited because he need to be out. I was so mad with his cousin was like, he's still in. I was like, God damn, I didn't check. That 2-for-1, he got it. So what's been happening is John's been signing still like 2-for-1. The jail is considering that not credit for time served, and people just been staying in.
Wait, what?
So you gotta check all your probation revocations.
You know, anything.
order, man, see.
Oh, and they're, yeah, considering it. So then people to confront.
How do you want folks situated for this with our one inmate? Do you want Mr. Kitchens to be at the table? And let's do what Ms. Wood wants. And then Mr. Turner and Mr. Patterson can be up at the podium.
Perfect.
All right, Mr. Turner, come on up. Thank you.
Thank you.
Yeah, it's the first time.
You guys should switch positions. Ms. Rivers, did we give you long enough break?
Yes, Judge, I'm ready.
Excellent. All right, we are going to get on the record then with positions 22 and 23 on the trial calendar. It's State versus Elijah Kitchens and Correll Turner, 25 SC 005882. Mr. Kitchens is here with his lawyer, Ms. Wood, and Mr. Turner is here with his lawyer, Mr. Patterson. Good morning to both of you. Mr. Kitchens and Mr. Turner, your lawyers tell me that you're prepared to go forward with a plea. Is that correct, Mr. Kitchens?
Yes, Your Honor.
Okay, and is there a green light on the microphone in front of you?
Yes.
Great. Mr. Turner, you're prepared to go forward with the plea?
Yes, Your Honor.
All right, Ms. Smith is here for the state. She is going to put both of you under oath in just a moment, and she's going to ask each of you the same questions. There are a bunch of questions, and she'll ask the question once. What is your name? And then she'll say, Mr. Kitchens, and you'll give whatever your answer is. And then Mr. Turner, and she doesn't necessarily need to go in that order. But for each question, she'll need to get an answer from both of you. Please wait until Ms. Smith says, Mr. Kitchens or Mr. Turner. Don't answer at the same time. The court reporter can only take down one voice at a time. Some of the questions may be for counsel, but then Ms. Smith will say Ms. Wood or Mr. Patterson. It's important that we all speak individually and not over each other. But this will be more efficient if we take the pleas together. Mr. Kitchens, if at any point during the conversation we're having, you can't hear what's going on or you've got a question about what's going on, will you let me know?
Of course.
Okay. Mr. Turner, same thing. If at any point you've got a question, we keeping you up?
Yes.
No? You'll ask a
Yes, Your
question?
Honor.
Okay. All right. Ms. Smith.
Yes, Judge, thank you. Mr. Kitchens and Mr. Turner, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth? Mr. Turner?
Yes.
Mr. Kitchens?
Yes.
Okay, you can lower your hand. Please state your true, correct, and legal name. Mr. Turner?
Correll Javon Turner.
Mr. Kitchens?
Elijah Kitchens.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine? Mr. Turner?
No.
Mr. Kitchens?
No, ma'am.
How old are you and how far have you gone in school? Mr. Turner?
19, but I had got locked up, so I couldn't finish school.
So how far did you go in high school?
12th grade.
You didn't graduate though?
No.
Okay.
Mr. Kitchens?
Graduated high school.
How old are you?
23.
Are you able to read, write, and understand the English language, Mr. Turner?
Yes.
Mr. Kitchens?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial. Mr. Turner, you understand that?
Yes.
Mr. Kitchens?
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment, Mr. Turner?
Yes, ma'am.
Mr. Kitchens?
Yes, ma'am.
Do you need more time to discuss your case with your attorney, Mr. Turner?
No, ma'am.
Mr. Kitchens?
No, ma'am.
And are you satisfied with their services, Mr. Turner?
Yes, ma'am.
Mr. Kitchens?
Yes, ma'am.
Mr. Patterson, are you satisfied that your client has a full understanding of this proceeding?
I do.
Ms. Wood, same for you.
I am.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea, Mr. Patterson?
So waived.
Ms. Wood,
So wait,
do you remember being arrested on these charges, Mr. Turner?
Yes, ma'am.
Mr. Kitchens?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Are you aware of any outstanding warrants, Mr. Turner?
No, ma'am.
Mr. Kitchens?
No, ma'am.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 15 years to serve 3 with the balance probated? Mr. Turner?
Yes, ma'am.
Mr. Kitchens?
Yes, ma'am.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and can run those sentences consecutively? Mr. Turner? I can repeat it if you need me to.
Yes, can you repeat it for me?
Are you aware that the court does not have to accept that 15 serve 3 balance probated offer I just stated, and that they can sentence you to the maximum on each charge that you're charged with and can run those sentences consecutively?
Unless if we do anything after?
No, they're saying that's the possibility that the judge could give you. not that
Right,
you
so
get-
Ms. Smith is going to recommend a sentence, and it sounds like it's 15 years to serve 3 years with the balance on probation. I was not part of the negotiations, and so Mr. Patterson, is this a negotiated plea?
It is.
So Mr. Patterson is going to try to convince me why I'd agree to 15 to serve 3, but he's not my boss. And so he can be very persuasive, but in the end, I might say, I've learned enough about Mr. Turner and this situation and what happened to Marquise Reese. And so I think it should be 15 to serve 5. I don't know that I'll do that, but you need to understand that the state's recommendation doesn't bind me. I'm going to do what I think is the appropriate thing after I learn a little bit more about you and a little bit more about the case. And it may well be 15 to serve 3, but there's no guarantee. You understand that?
Yes.
All right. Mr. Kitchens, do you also understand that?
Yes, ma'am. Wait, I have a question though. What do you mean by a bonus probation time?
Oh, balance probated?
Oh, balance probation.
Balance probated. So is it also 15 to serve 3 for him? So it means 12 years probation.
Okay.
If I accept all this, I'm ultimately sentencing you, again, if I accept it, to 15 years. Of those 15, 3 are to serve, credit for time you've already done, and the remaining 12, that's 15 minus 3, the remaining 12 would be probated. That's the balance there's no bonus probation, but the balance is probated. Okay?
I understand.
Okay. Do you understand that you're pleading guilty to armed robbery, and that is a serious violent crime? Mr. Turner?
Yes, ma'am.
Mr. Kitchens?
Yes, ma'am.
Do you understand that you will serve the entire prison portion of the sentence imposed for a serious violent felony without the possibility of parole? Mr. Turner?
Yes, ma'am.
Mr. Kitchens?
Wait, can you repeat that one more time?
Yes. Do you understand that you will serve the entire prison portion of the sentence imposed for the serious violent crime without the possibility of parole?
Yes, ma'am.
Do you understand that while you could be eligible to be considered for participation in a Department of Corrections administered transitional center or a work release program during the final year of your incarceration, you will not be eligible for any other sentence reducing program of the Department of Corrections or Board of Pardons and Paroles? Mr. Turner?
Yes, ma'am.
Mr. Kitchens?
Yes, ma'am.
Do you understand that neither the court nor the district attorney's office has anything to do with parole or the Department of Corrections or Board of Pardons and Paroles, and that no one can guarantee you parole? Mr. Turner?
Yes, ma'am.
Mr. Kitchens?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or special conditions of probation without being subject to revocation for the balance of the sentence? Mr. Turner?
Yes, ma'am.
Mr. Kitchens?
Yes, ma'am.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history? Mr. Turner?
Yes, ma'am.
Mr. Kitchens?
Yes, ma'am.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case? Mr. Turner?
Yes, ma'am.
Mr. Kitchens?
Yes, ma'am.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering this guilty plea today? Mr. Turner?
Yes, ma'am.
Mr. Kitchens?
Yes, ma'am.
Are you a United States citizen, Mr. Turner?
Yes, ma'am.
What about you, Mr. Kitchens?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes, ma'am.
Okay. Mr. Kitchens?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense? Mr. Turner?
Yes, ma'am.
Mr. Kitchens?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty? Mr. Turner?
Yes, ma'am.
Mr. Kitchens?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed, and you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial. Mr. Turner?
Yes, ma'am.
Mr. Kitchens?
Yes, ma'am.
Mr. Patterson, are you satisfied that your client understands that these are the rights that they'll be waiving by entering this plea?
That is correct.
Ms. Wood, are you satisfied that your client understands that these are the rights they'll be waiving by entering this plea?
I am.
Has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea, Mr. Turner?
No, ma'am.
Mr. Kitchens?
No, ma'am.
As to indictment number 25 SC 0058882, Mr. Turner, how do you plead to count 1, armed robbery, count 2, aggravated assault, and count 3, possession of firearm or knife during commission of or attempt to commit certain felonies? Guilty or not guilty?
Guilty.
Mr. Kitchens? Go ahead.
Go ahead.
No, ma'am.
Okay.
Mr. Kitchens, how do you plead to count 1, armed robbery, count 2, aggravated assault, and count 3, possession of firearm or knife during commission of or attempt to commit certain felonies? Guilty or not guilty?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you? Mr. Turner?
Yes, ma'am.
Mr. Kitchens?
Yes, ma'am.
Do you understand that you do not have a direct right to appeal from your guilty plea conviction, but if you believe that there's some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal? Mr. Turner?
Yes, ma'am.
Mr. Kitchens?
Yes, ma'am.
Do you understand that that process has to be completed within 30 days from today? Mr. Turner?
Yes, ma'am.
Mr. Kitchens?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this plea? Mr. Turner?
Yes, ma'am.
Mr. Kitchens?
Yes, ma'am.
Thank you. Your Honor, if this case were to proceed to trial, the facts would show that on December 20th, 2024, officers of the Atlanta Police Department got a call reference to a robbery at 2975 Continental Conley Parkway Southwest. That's in Atlanta, Georgia, and also in Fulton County. When the officers got there, they met with McQuwell Reese. First name is spelled Marquis, last name is Reese, Reese. Mr. Reese told the officers that he had just been robbed by 3 black men while trying to sell a diamond necklace that he was selling on Facebook Marketplace for $1,500. He told the officers that he was conversing with a profile on the Facebook Marketplace website. It presented as a female named Janiyah Johnson. However, the person that was actually behind that Facebook page were the defendants in this case. They agreed to meet up with Mr. Reese to buy this diamond necklace that he had. They agreed to meet up on December 20th, the day of the robbery. On this day, Mr. Reese reached out to that Facebook page, giving them the location and the time to meet. He also sent kind of a video of what he was wearing and where he was located on the property. The incident location is an apartment complex. So he's at the front of the apartment complex is where they were supposed to meet. Mr. Reese told officers that the person on the Facebook page told him that they would be pulling up in a silver Mercedes car. However, what he saw was a white Mercedes pulling into the incident location. A couple of times they would circle around, but then during this time, they're also still conversing on Facebook about like, where are you and things like that. Mr. Reese indicated that the Facebook page asked him, could he like go down the street or to an alternative location so they could meet? He declined and then started walking toward the leasing office and told them to then meet him there. While he was walking to the leasing office, he saw it was 3 people in the car, and he was able to see who was driving when they pulled in because they went around 2 times based on the facts. But he saw the driver get out of the car and then get back in. The driver didn't run upon him or anything like that. However, the person that was sitting behind the driver, so the back passenger seat, that person got out of the car, started jogging toward Mr. Reese, pushed him in the bushes, put a gun, pointing a gun at him and told him that if he bucks, he would shoot him. He then proceeded, that person that had the gun in their hand, he then proceeded to take the diamond necklace that Mr. Reese had and also his phone. At this time, the person got back into the car and the white Mercedes sped off. That phone that was stolen from Mr. Reese was thrown out of the window, maybe 2 blocks down. The officers were able to recover the phone and they gave the phone back to the victim in this case. While the victim was talking to police officers, he also stated that he was able to get kind of some of the numbers and the letters from the white Mercedes. It was a dealer's tag, but based on him looking at the tag, he was able to configure some letters and numbers. So because of video technology in this case, officers of the Atlanta Police Department were able to find a tag that matched the one that was at the scene of the robbery. And they kind of screenshotted them going throughout the city, passing Greenbrier Mall and that side of town. And eventually they lost track of where they were around 4 o'clock. This robbery happened around 3. So later that day, around 11:30 p.m., it was a bolo put out for that white Mercedes. So it was an officer working an extra job at the location where they found the car. The officer then called back up with the Atlanta Police Department and said, hey, we found the car that was involved in the robbery earlier that day. They detained the 2 people that was inside of the car. The driver was Mr. Elijah Kitchens, and the second person, his name was Shakir. However, he was not detained or charged in this case. He was just a passenger at that time. Now, when the officers detained Mr. Kitchens and this other passenger on that same day, just hours later, they kind of asked after reading their Miranda rights, they kind of asked Mr. Kitchens, where have you been? He said he had the car since 10 a.m. or 11 a.m. that whole day. He went to South Lake Mall. They went and bought some items or looked around. And then eventually they were in that area because they were trying to pick up girls or like talk to girls, go to the club and things like that. But Mr. Kitchens did place himself inside of that car since 10 or 11 a.m. While on the scene, the day that the car or around the time that car was found, the owner of the car, Ms. Shannon Turner, who is the mother of Pharrell Turner, came on the scene and stated that she had tracked her car, the white Mercedes, to that location. She asked multiple times where was her son, because at that time, like I stated, Mr. Kitchens and a passenger was in the car, but Mr. Turner was not. So she asked where her son was, and then she also indicated that she gave her son, Mr. Turner, the car around 9 a.m. so he could go to school. At that time, I believe he was going to Monroe High School, and she would usually give him the car to go to school and he brings it back. However, on that day, this is when the robbery occurred, but her saying that she gave him the car, placed him also in the car, the same car that was used at the robbery. So on that night at around 11:30, after that was over, they were detained, but both people were let go. So Mr. Kitchens were let go and the passenger was let go because at that time, the officers did not have enough to take out a warrant based on just the description of the car. However, the warrants were later filed for both defendants in this case. A couple of days after so on that day, the car was taken to annex also, it was impounded. But the 2 people that were driving were excused. So at this time, the investigator Pender, he went and saw the victim, Mr. Reese, and did a photo lineup based on the driver that they found that night in the car and also Mr. Turner from the name that we got from his mom. The victim in this case positively ID'd Mr. Elijah Kitchens as the driver of that white Mercedes that was in the car during that robbery, and Mr. Turner as the person who got out of the back of the car, who ran up to him, put the gun to his face and said, if you buck, I'll shoot you. At this time, the officers then placed warrants out for the arrest of both co-defendants in this case. Also, when the car, the white Mercedes, was searched, they were able to find that jewelry box that the necklace came in. The necklace was not in there. However, the box was in there. They also found a couple of guns, 2 guns in particular, one under the driver's seat and one under the passenger seat. One of those guns the victim said it was a Ruger style gun. He didn't know the exact gun, but one of the guns did match the description of the gun pointed in the victim's face. Eventually, both defendants were apprehended and arrested for the charges we have before us. Those are the facts of the case. It happened in Fulton County. Regarding the negotiated plea between myself, Mr. Patterson, and Ms. Wood, we're recommending 15 years to serve 3 with the balance probated. So how that would look is for the armed robbery and the aggravated assault, 10 years to serve 3, and then for count 3, that's that 5-year consecutive, making it 15 serve 3 balance probated. Regarding the special conditions of probation, the state is asking for both defendants to complete an anti-theft course, 150 community service hours, for there to be gainful employment, for there to be banishment from Fulton County, not even to work, not even to come and play, to stay away from Fulton County, for them to have no guns or replicas, and also if they have not completed high school to get their GED. We may also be asking for restitution in this case for that diamond necklace, but I don't have those receipts yet from the victim. Regarding we stayed with the armed robbery in this case, Your Honor, but regarding the deviation, it is a mandatory minimum of 10 years. However, the state took into account a lot of things. We did believe that the case we had here was strong. However, one of the main issues we had was the victim in this case. It happened in 2024. Over time, people seem not to care about these things that happen to them anymore. So we've been talking to the victim. However, he's pretty reluctant on participating or continuing to talk to us. He does acknowledge that this happened to him. He acknowledges that he got beat the defendants and that this happened. But as far as him participating to the fact where the state could use him during trial, that became an issue. We also looked at the kind of the age and criminal history of the defendants in this case, and they don't have a long rap sheet. But however, we believe that since it's under armed robbery, it's 3 years to the door, and after they get out, they'll be on probation for those 12 years, and the state would like to have them make the most out of those 12 years based on them not pleading to the mandatory minimum of 10 years.
Got it.
But that is all from the state, Your Honor.
Okay. So I'm clear. Found in Mr. Turner's mother's Mercedes that Mr. Kitchens was driving when the police came to it, and that Ms. Turner said, I gave to my son to take to school, but they did everything else with it instead. Inside that Mercedes was a jewelry box that Mr. Reese positively ID'd as that's the box the necklace was in.
Mr. Reese, when he talked to the police initially, he described the box and what it looked like.
Yeah.
That was the box fit that description of the box that was found. They never
Okay.
took the box back and he said.
And showed him, but it fit the description. It just unsurprisingly was empty.
That's correct.
Okay, got it. Thank you.
Yep. Yana, can you give me 2 seconds? Let me speak to his dad, just 2 seconds.
In a moment, let me hear from Ms. Hardy, and then we'll close the state's chapter on this. Ms. Hardy, what do you have for criminal history? We'll start with Mr. Kitchens.
There's 5 arrest cycles, 4 arrests out of Georgia, 1 out of Texas. There was a conviction in 2022 for burglary and theft by taking where they got first offender treatment and no seal date was listed.
Got it. Ms. Simpson, is Mr. Kitchens still on probation in that case? Oh, all right. And I noticed he's been in Cobb some, so we'll hear from Ms. Wood about that. All right. And Ms. Hardy, Mr. Turner, criminal history.
Mr. Turner has 2 arrest cycles in Georgia, no felony convictions reported on his GCIC.
Got it. Okay. Mr. Patterson, you want a quick moment to speak with Mr. Turner's father?
Absolutely.
Okay.
You can't make that decision. He'll leave that solely up to you. Because if he shows up, you will get 10 years. If he doesn't show up, they don't have a case, but I can't make that decision. You have to.
Yeah.
No, this is it. It's right here and now. Remember, we have been over there. Remember, he said he identified you, remember?
It wasn't me.
Right, then you want a trial. I don't have a problem with that. Do you want a trial or do you want to go to the witness? I do either one you want to do. Which is it?
No, let's just take it.
You still want to proceed with the trial? I mean, with the plea, I mean. Now, my client still wants to proceed with the plea, is that correct?
Yes.
Okay, well, we'll do that. So where we are now, Mr. Turner and Mr. Kitchen, is that I'm going to hear from your lawyers. I'll start, Ms. Wood, with you on behalf of Mr. Kitchen. If there is anything you want to share on his behalf.
Yes, Judge, thank you so much. So he has been in Cobb County. I'm working to get the proof of incarceration for Ms. Nelson. I believe since May of last year, he was in Cobb when he was arraigned for this case. So he has been in custody since then. I'll get those actual dates for the court. So we would ask if the dates be included on the final disposition. Judge, she's a lifelong resident of the metro area. He does have family support. I've spoken with his mom and his uncle. His girlfriend Josephine is actually here. She's on the back row. He lived in Clayton County before this arrest, Judge. He is on probation in Cobb. He also has an unindicted case in Cobb, so he understands he's got to go work through that as well. He's 23 years old. He's a high school graduate. Judge, he was working as a valet and also doing landscaping before he got tangled up in this case. He's accepting responsibility. He's a bright young man, Judge. I do believe that he knows better, that he can do better. And so I'm eager to hopefully never see him again in a jumpsuit. And I just ask that you accept the state's recommendation in this case.
Okay, appreciate that. Mr. Kitchens, is there anything you want to add?
No, Your Honor.
Okay. Mr. Patterson, on behalf of Mr. Turner.
Your Honor, Mr. Turner, as the court is aware, he does have family members here, his father, he's got his friends and other relatives. But Your Honor, my client, although he asserts that he never had a weapon, he does not want to take a chance of going to trial, potentially being convicted and given a mandatory minimum. He asserts that he certainly accepting responsibility, although reluctantly, he feels that he does not want to take a chance on any trial. We ask the court to accept the state's recommendation in this case.
Okay. Mr. Turner, is there anything you want to add?
Yes.
What's that?
I was asking, can I get time to at least have one more day with my family?
So we're going to talk about that, about a turn-in date. That's one of the topics I need to go through with you and your lawyer and with the prosecutor, okay?
Yeah.
We'll get there. All right. Ms. Smith, you shared a bit about recent communications with Mr. Reese. Has he given you a perspective on what he thinks about a reduction below the mandatory minimum?
Yes, he doesn't have an issue with the reduction.
Okay, all right. Well, Mr. Kitchens, I'm going to start with you. I find there's a factual basis for your plea. Sounds like you were the wheelman in this business. It was risky, it was dangerous, whether there was a gun deployed on Mr. Reese or not. There were guns in the car. You guys don't know if he's got a gun. He could shoot back. Anything could have happened that could have ended a whole lot worse than this. But here we are. I do think that had the state gone forward, it could have proven beyond a reasonable doubt that you were a participant in this. You don't need to be the guy who took the belongings. You just need to be party to a crime. I don't know what the jury would have done, but they could have convicted you, and I would have found that to be a verdict supported by the evidence as Ms. Smith has described it. I also find that your plea is knowing and voluntary, meaning you've understood what we talked about, and when you didn't, you asked, and we cleared that up. And voluntary means no one's forcing you to enter this plea. Do you agree with that?
Yes, I do, Your Honor.
Okay. Mr. Kitchens, do you authorize someone in my office to sign the indictment on your behalf indicating your guilty plea?
We do it electronically now, so you don't just be saying, we agree.
Not normally, 10 years ago, we used to hand the indictment around and you'd sign it and say guilty. But now we just have people in the office electronically put your name on there. They'll say Elijah Kitchens, guilty, which you've already said here in court, but we just put that on the indictment. Do you have any objection to us doing that?
No, Your Honor.
Okay. Ms. Wood, any objection from you?
No, Judge, thank you.
And Ms. Smith?
No, Judge.
Okay. Mr. Kitchens, the state and your lawyer have asked me to deviate below the 10-year mandatory minimum. That means they're invoking, and I need to say the statute for the record, 1710 6.1E. I don't have to do what they're asking, but they've helped me understand why maybe I should. And so I will. You will get credit for all the time you've been in from the day of your arrest in connection with these charges. I don't know when that day was. I've got you being booked into the Fulton County Jail the first time on December 8th of 25, which seems late in the game, but there's probably some COB time in connection with that. And if that COB time was linked to a probation warrant that was based on these charges, then you'll get credit for that as well. But I don't want to mislead you. I don't make those decisions, but the law is very clear. Anytime you've been in custody in connection with these charges, or since you were first arrested for those charges, even if you were in Paulding County, doesn't matter what county you're in, you get credit for all that towards the 3 that you're going to serve. Do you understand that?
Yes, Your Honor.
Okay. So I'm sentencing you on counts 1 and 2 to 10 years to serve 3 years with the balance on probation. Count 3 has to be consecutive, has to be 5 years. So it's a total sentence of 15 years to serve 3, balance probated. 3 to serve to the door, followed by 12 years on probation. And I appreciate the community service piece. I think you will have done enough time that then having you do community service is a little disconnected from the offense. But I will include the condition that while you are on probation, you cannot be in Fulton County. That leaves you a whole lot of Georgia, no Fulton County. Okay?
Yes, Your Honor. So that means since I did time already, no community service, just don't be in Fulton County during probation.
Right. When you are released and you can do the math because you've got to do the 3 full years. You don't need to worry about, gosh, when might I be paroled? When you're released, you will then be on probation. That probation will be based in whatever county you live in, not Fulton County. There are no conditions to your probation other than the standard one, which is obey the law. So obviously, and you learn this out of Cobb County, if you get arrested for something after you're released from prison, not only do you have that new situation wherever it is, but you're going to be coming back here and you will actually be allowed in Fulton County because you can come through that door. And we'll deal with what the consequences are of having violated your probation in this case. My hope is you're done with the arrests, but I don't control that. You do. Okay? Did I answer your question?
Yes, Your Honor.
All right. Mr. Turner, I find there is a factual basis in your case, and that your plea is also knowing and voluntary, meaning you've understood what we talked about. And when you didn't, you asked your lawyer to explain it. And voluntary, again, just meaning no one's forcing you to do that. Do you agree with me?
Yes, Your Honor.
Okay, I'm accepting your plea. Ms. Smith, can someone in my office sign the indictment for you?
Yes, Judge.
And Mr. Patterson, can we sign for you?
Yes, Judge.
And Mr. Turner, can we electronically sign the indictment for you as well?
Yes, Your Honor.
Okay. I'm going to sentence you in the same way with one additional condition, but counts 1 and 2, I'll let you ask a question in a minute, are 10 years to serve 3 years. Again, I'm invoking 1710 6.1E. Count 3 has to be 5 years. It'll be consecutive and it'll be probated. So it's 10 to serve 3 balance probated plus 5 probated, which gets you to the sentence your lawyer negotiated. 15 to serve 3 balance probated. You were in custody for a little while. You've been out on bond for a while. We deal with you and your ankle monitor. But the time you've been in, you get credit for that. You have two special conditions when you get out. One is stay out of Fulton County. Can't work here, can't, as Ms. Smith put it, play here, can't be in Fulton. Number two, if you do not get your GED while you're in custody, you got to get it and enroll within the first 6 months of your probation when you get out. I hope that's what you do. One of the things you do while you're in custody. You have plenty of time to get that GED. But if you choose to do other things, then you'll need to enroll within the first 6 months you're out, and it's part of your probation. Any questions about that?
No, Your Honor.
Okay. Ms. Smith, do you have a perspective on whether Mr. Turner should go into custody now or whether he could turn himself in on Monday?
Monday's fine, Your Honor.
Okay. Mr. Turner, you can turn yourself in here Monday morning, 9 a.m. If you are not here at 9 a.m. on Monday morning, your sentence is not 15 to serve 3. It's 15 to serve 10. Okay? It's gonna be that easy. I'm gonna have 2 sentences to sign. One that your lawyer negotiated. If you are not here, I'm telling you now what the sentence is, so I can sentence you in absentia, meaning you're not here, and I'll sign the paperwork that gives you, there's no deviation downward. It gives you the full 10, no parole for armed robbery. And you know, in the end, folks are gonna catch up with you and you'll start your 10-year sentence at age 20 or 21 or whenever it is. So you will buy yourself 7 years without parole if you are not here Monday morning at 9 a.m. Okay?
Yes, Your Honor.
Any questions about that?
No, but I just want to say thank you to Ms. Smith and thank you to you.
You're welcome. Use these next few days wisely. Getting arrested over the next few days could complicate things as well. So do what you need to do to tie up loose ends, be with family and friends. And when are you going to be back here?
Monday, 9 a.m.
Right. If you are running late for any reason, you call Mr. Patterson so he can call my chambers. And if I have Mr. Patterson saying, hey, Mr. Turner's on 75, he's going to be here in 10 minutes, then we stay calm. But if it's 9:15, there's no Mr. Turner, I just sign another sentence. And if you walk in at 10 o'clock, but there was no phone call, you're walking into a 10-year sentence. So don't goof around on that one.
I won't.
When you show up, dress real simply. Not even the button-down shirt. I know you did that for court, but don't bring a bag, don't bring a phone, just you and some clothes that if you never see them again, you're okay, because I don't know that you'll ever see that set of clothes again. All right?
Yes, Your Honor.
Mr. Patterson, anything else on behalf of Mr. Turner?
No, Judge.
All right, Ms. Smith, anything else on behalf of the state?
Nothing further, thank you.
Ms. Wood?
No, Your Honor, thank you.
All right, thank you, everyone.
Great.
Can you quickly address Mr. Brown's fees? Is it possible that between housekeeping, this man is agreeing to it and focus on the restitution payment?
I will waive fees if there ends up being restitution. To date, we have never, ever had restitution. But if we have restitution in something, then people move on. That's what happens. So, but if we've got restitution, it'll be a 1-for-1 swap because it is much more important that the restitution be paid than JCS. All right. Can we do?
Can we approach on the Browning case?
Yes. Yes. As in like go into the jury room?
Yes.
Okay.
Also, I forgot, quickly, I have an Adderall that's walking in from I just realized it's probably wasn't on the calendar for events where it's set aside for my previous trailer.
Okay, let me have this conference. I'd love, if it's gonna be a plea, to do the plea. We have to stop at about 12:20. Then we'll pick back up, but we need to give all of the folks supporting this process a lunch break. And so that's coming up soon.
So I just end up having to just do it on my phone.
Okay.
Oh, you know what? Let's do it like that. Super.
You're the app anytime?
I think we might be full.
Okay.
I feel like I have everything way on this.
Yes, probably. So it's okay. That's why I was saying, we can do this. Yeah. I might shop. I think you'll. Yeah, I'm gonna go and then get back in my. It might be because it's over.
Yeah, it's a small hungry. But I didn't want him to leave because he's pregnant, he has suspension on it, I didn't want him to be worried about that the whole weekend, so. But, okay, if you have a good. Oh, that's nice. Oh, you wasn't. Okay, but, yeah, so probably. Okay. Unless they're gonna do the plea, but you have a plea too. You get your plea done because I know you haven't.
I know, I'm like, if I get out of here at 5:20, I can probably speed walk.
Yeah, so why don't you just ask, well, after.
I was gonna say, she needs to go, if people let her do Zoom.
It's okay, simple, do you want me to?
Sounds a misdemeanor plea.
I can handle it.
Okay, I might do that.
I just.
Yeah.
Take a Stop. I already opened it. I'm cheating on it. That's fine.
She'll be back again.
Oh, yes.
Korea. Did you ever get the documentation from the children?
What?
Yes, at that.
Let me give it to me.
This is so good.
He has the original, but I didn't want to keep his. He has the original, but I didn't want to keep his original. Okay. I can keep this or? Yeah. That's it. So he was in this program for 18 months. So he started in 2024 and he missed court in September of 2025. So he was there for 18 months.
No, I have to work with it.
It was a small home. Were you housing this?
Yeah, but we're not physically housed there. Were you housed there?
Yeah.
So he was.
Yeah, he was.
Deputy
there.
Gordon.
Living there.
I see you for a second.
And that's his bill, the bills.
Yeah.
It was my understanding that it was a housing type of program. Yes. There, so. He did not know it. Yes, so we put it in this program that was 18 months, that he completed. I think he was on drugs and he was just trying to get better and focus in the program. Okay. Okay.
All right. Ms. Browning, if you and Mr. Blevins could come on up to the podium, please. Oh, okay. If we could get her.
I'll get us a turn from
Mr. Argus is still here?
Yes.
Okay, he's just pacing?
Yes, sir.
Okay.
We all have.
When we have school institution, is that a motion or is this something that we try to say?
I'm fine with it being informal like that. Just reach out to, because you would always bring it up. It's not like it's going to be a surprise. Sometimes you're able to follow through. Sometimes they don't get you the paperwork. I would just reach out to Ms. Nelson and say, could we have a restitution hearing in 26 SC, whatever it is? She'll know the case, and that person will already have a final disposition. So it's like a sentence modification. You know, as long as you're letting the other side know, hey, because we shouldn't have a hearing if you haven't given them paperwork. So we might be able to skip the hearing. It sounds like with Mr. Brown, if it's all Grady records and you slide it across and it's not for, I broke my arm, because that's not what happened to her, that Ms. Rios and her client are going to say, it's fine. And then we don't need a hearing. Because if we need a hearing, he's got to come on in and deal with it. He may prefer just to, so share it with the other side, see what they say. And if they say we don't object, then it's just, could you modify the sentence? And as long as I see opposing counsel on that email, I'll modify the sentence. It's only if they're pushing back that then we'll have a hearing. Okay. All right. Ms. Browning, good morning.
Good morning.
It's a difficult time, I know, but you've got a lot of support here, and those people will stay your supporters throughout this process. Mr. Blevins let me know some of what happened this morning. And what I'm going to do is this. I'm going to revoke your bond because you used. I'm not saying anyone needs to bring charges, but for your safety and for the certainty of you being here for the plea in your case, I'm revoking your bond. So you're going to go into custody right now, and we're going to come back on Monday or Tuesday. We're going to sort out what works with Mr. Blevins' schedule and Miss schedule, but it is next Monday or Tuesday. It's not later than that. We are going to bring you back here, and we're going to go forward with the plea that you and Mr. Blevins negotiated with Ms. Smith. I don't think Ms. Smith is changing anything about the plea. So whatever, was it a negotiated plea?
It was, Judge.
So whatever you were expecting, that's not going to be different because of what happened this morning. We're going to do the same thing. Just a reminder, if in case you were in here when I was dealing with the two young men on that, I'm not bound by the plea. By the negotiations, I still need to hear about what happened, and I might think that it's too low or too high. I generally defer to what the experts on the case have done. But most importantly, we'll get that closure of the plea on either Monday or Tuesday. Okay?
Sure.
Any questions? Okay, you're gonna go with Deputy Gordon, and we'll get you back here on Monday or Tuesday. Thank you, Mr. Blevins.
Thanks, Judge. That's all I have, maybe excuse.
Yes.
I'll be in touch with you all.
Okay. Counselor, you stand alone.
Judge, I'm sure I don't need to tell you this, but obviously drug addiction is it's an illness, it's a disease. My client, I got him on the phone, but he's under the influence. I just hope by the grace of God, he doesn't die of an overdose. So at this time, I would ask that the state move with what I think is going to happen next is a bench warrant.
Right. We'll do a bench warrant. And that way, if there is a soft encounter with law enforcement, we can get Mr. Rayborn that way. And we'll see how it flows. And you'll get notice when I get notice. And really up to the state what they choose to do with the offer that was out there. I'll be available for a plea or whatever it is we need to do, and we'll keep you posted.
Understood, Judge.
Okay.
Thank you very much.
You're very welcome.
Charlie told me to say hi to you, by the way.
Okay. All right.
Take care.
Thank you for those of you who are here on behalf of either Ms. Browning or Mr. Rayborn. Appreciate your time. Take care. So we got a bonus window before we break for lunch. Ms. Wood, what can we do for you?
Well, it's for everyone else too. I'm making the day move along.
You were great for Ms. Willingham. She owes you. Look who's here. Let's take her case.
Position 14, Ms. Nesby. It's a negotiated misdemeanor plea.
All right. You don't want to do that?
No, yes. I just, yeah.
You apparently weren't taking Ms. Smith's interests into consideration.
It'll be quick, I promise.
You said 12. It's good enough.
We're close. We're so close.
All right, so we will take care of that and then take stock of what, if anything, is left and make a plan for the afternoon, if there's anything left. So that went away. Let me know when you're ready.
I am ready, Judge.
All right, you don't give me much time. Let's get on the record. Position 14, it's State versus Nesby, 225 SC 005-432. Good morning, Ms. Nesby.
Hello.
How are you?
Good, how are you?
I'm okay. Ms. Nesby is here with Ms. Wood, and Ms. Smith is handling this for the state. Ms. Nesby, it sounds like you are prepared to enter a plea to something being reduced because it's a misdemeanor plea, and I'll hear about that from Ms. Smith. You've got to be put under oath, and then you'll be asked a whole bunch of questions about your case and your rights. You need to answer those questions truthfully. You also need to let me or Ms. Wood know if at any time you have a question. Will you do that?
Yes.
Okay, and make sure when you're answering questions, you're welcome to nod or shake your head, but you also have to answer verbally because the court reporter only takes down the spoken word. All right?
Okay.
Great. Ms. Smith?
Yes, Judge. And to be clear, you know about those reductions that we're doing today, or would you like me to?
You said it, someone said it's a misdemeanor plea.
Okay.
That's all I know.
So for count one, it'll be reduced to battery, that is OCGA 16-5, 23.1.
Mhm.
And then count two will just be the misdemeanor version of willful obstruction, so same OCGA code.
Okay, thank you.
Ms. Nesby, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Joel Nesby?
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
And is there any medication that you would normally take that you haven't been given today?
No.
How old are you and how far have you gone to school?
I'm 19 and I'm in my first year of pursuing nursing.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes.
Do you need more time to discuss your case with your attorney?
No.
And are you satisfied with her services?
Yes.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
I am.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
We do.
Ms. Nesby, do you remember being arrested on these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
No.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 24 months probation?
Yes.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and can run those sentences consecutively?
Yes.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes.
Do you also understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes.
Are you a United States citizen?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this guilty plea?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by entering this guilty plea?
I am.
Ms. Nesby, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No.
As to indictment number 25 SC 005432, how do you plead to the reduced count of battery for count one and the reduced count of willful obstruction of law enforcement officers for count two?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you do not have a direct right to appeal from your guilty plea conviction? But if you believe that there is some type of error in your guilty plea, that you can apply to the appropriate appellate court to request a discretionary appeal.
Yeah.
Do you also understand that this has to be completed within 30 days from today?
Yes.
Do you understand that you have only 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes.
Thank you, Ms. Nesby. Your Honor, if this case were to proceed to trial, the state would show that on June 30th, 2024, officers of the Sandy Springs Police Department were dispatched to 8604 Roswell Road, Sandy Springs, Georgia, also in Fulton County, regarding an active fight between employees and two females. That location that I mentioned is a Waffle House location. So two employees that work for Waffle House and two female customers. One of those customers being identified as the defendant in this case, Ms. Nesby. When the officers got there, he could see from a street level that there was some type of altercation that was happening inside. When the officers went inside, they saw Ms. Nesby fighting with one of the victims that's listed in the case, Michael Wilson. He saw that they were fighting. She had a closed fist, and she also picked up something from the table and threw it at Mr. Wilson. They made contact with him. However, at that time, the officers were able to take Ms. Nesby. There was a second person there with Ms. Nesby, but she is now in this indictment that was getting into that altercation. But the officers were able to separate Ms. Nesby from the employee and place her under arrest. While they were trying to get her under arrest, though, Ms. Nesby was resisting, trying to get away, not being handcuffs and things like that, kind of making it difficult for the officer in this case to place her under arrest. The officers were able to get video footage that I also reviewed where Ms. Nesby walks into this Waffle House. There's some type of interaction between her and Mr. Williams and also the second employee that was at that Waffle House location. And that verbal altercation turned into a physical altercation between both of the victims listed and also Ms. Nesby and that second person that was with Ms. Nesby. Because of this fight that occurred, the officers did arrest Ms. Nesby for the charges we have before us today. Those are the facts of the case also occurred in Fulton County, as I stated before. Regarding the negotiated plea between the state and the defense, we've agreed to, for count 1 and count 2, 12 months probation for both of those counts to run consecutive for a total of 24 months on probation. Regarding the special conditions of probation, the state is asking for the defendant to stay away from that specific Waffle House location, for the defendant to have no contact with the victims, complete an anger management course, and also complete 30 hours of community service. That is the negotiated plea. Regarding the reduction in this case, the state attempted to get into contact with the victim multiple times, but I was told by Ms. Wood that there is a previous relationship between the defendant and the victim in this case. The defendant was dating the victim was dating the defendant's mom, and something occurred on that. Do I need to? I'm confusing you.
No, okay, so Mr. Williams was dating Ms. Nesby's mom.
That's correct.
Got it. I was like, wait, how did mom get in the mix?
That is
Don't drag
correct.
her into this. Got it. So it wasn't Williams and Nesby, it was Williams and, I'm gonna call it Nesby Senior. I know it doesn't work that way, but
Yes,
okay.
Yes, and I'll let Ms. Wood talk more about that relationship between those two and other court cases they have against each other. But from our point of view, when trying to contact the victim during TLOs, we were not able to contact him, and there wasn't any much willingness to participate in the process here. And looking at her history and all of the facts and circumstances in this case, the state did decide to reduce both of those cases to a misdemeanor. Hence the misdemeanor plea we're doing today. That is all from the state, Your Honor.
What is a TLO?
That's how we run the victims' names and get their updated contact information. So we're able to contact them.
Okay,
So we got the updated numbers, email addresses, and addresses.
got it. So you did a TLO on Mr. Williams to make sure you've got good info on him.
Right. And
Okay.
we called those numbers, but it didn't.
Okay. Thank you. Ms. Hardy, criminal history information, please, on Ms. Nesby.
There are 2 arrest cycles in Georgia, no felony convictions. Let's see, this case that's on the calendar and the other one is a shoplifting out of Alpharetta. Nothing further.
Okay, thank you. Ms. Wood.
All right, Judge, I'm going to try to get it right. So if I get it wrong, Ms. Nesby, I hope will correct me. So Mr. Williams, the victim in this case,
Who is a Waffle House employee.
at, yes, time of this incident,
Okay,
had dated Ms. Nesby's mother for a very long time, a number of years. At the time of this incident, they were broken up. But seems to have been a very messy situation. I shared this document with Ms. Smith. Mr. Williams actually just pled recently and received probation in Gwinnett County for a case against Ms. Nesby's father. So, yes.
Okay.
So there's a lot of moving parts here. So on the day.
A case against, as in Mr. Williams got physical with Ms. Nesby's father?
Correct.
Okay.
Yes, aggravated assault case.
Did he get to plead to battery?
He did not.
Okay.
So on the day in question, Ms. Nesby and her sister, that's the second person that was with her, they were headed to a store that was not the Waffle House. They saw Mr. Williams flagging them down. So they stopped, they went in the store. The second Waffle House employee was a new love interest of Mr. Williams.
Did he want to show her off, or what was I guess that's a question for Ms. Nesby.
Yes, Judge,
Okay.
I'm not sure exactly what happened, but
All right.
somehow, some way, words were exchanged between the new love interest and the girls, and it popped off from there. So that's how we landed here, Judge. I am just asking that you accept the state's recommendation. Ms. Nesby's 19 years old. She is a high school graduate. She's in nursing school. She's currently working as a certified nursing assistant at a healing facility. She's just ready to move forward, and I would ask that the court consider suspending or terminating the probation after a period of good compliance.
All right. Ms. Nesby, what's a healing facility?
Well, it's like where people go after they leave the hospital for like rehab, but we also have a long-term hall as well.
Okay, so it's something linked to a medical procedure. It's not you like rub crystals on them and try to channel positive karmic energy.
No.
Okay, so I'm curious. What went wrong? This was a long time ago. It was almost 2 years ago. But so Mr. Williams, like, hey, come on in here. What was the trigger? Was it something his new girlfriend said, or something?
Wasn't that? He had shot my dad like previously before that.
This is the case from Gwinnett?
Yeah. So
Okay.
he shot him, and when
So why would you go in if he's saying, hey, come on in here? Why don't you just show him one of your fingers and keep walking?
I don't know. I wasn't thinking, and I was in a bad headspace.
Is your sister older or younger?
She's younger than me.
Okay, so you led your little sister in there.
Not necessarily, but I did have her in my ear a little bit, so it
Okay.
kind of, messed with me a little bit.
So when you went in there, it wasn't to give him a hug, Mr. Williams. Like you weren't
No,
thinking,
but it
there's
wasn't
Mr.
to fight
Williams.
either.
No, I'm not saying that you were cruising for a bruising, but it wasn't, hey, he's waving at us, let's go give him a hug. That's Uncle Mike. No. Okay. All right. What'd you throw at him?
It was like a salt shaker, dude. Like it
There's
was
your glass.
But they
Okay.
like double teamed me, so I was like,
I'm not saying you shouldn't have thrown it. I wasn't there. And I probably would have stayed outside. Once you told him like, hey, who's that guy? Oh, that's the guy who shot my dad. I'm not going in with you. So, okay. And I don't mean to make light of it. You've been charged with this. You were in jail for 2 days, and it may well be Mr. Williams was hurt and shouldn't have happened. But it sounds like you get it. That's the most important part. And that going forward, if you had your little sister with you, it's like, we're not going in there. All right. You give them whatever hand gesture you want. We're going to keep going in our way, because that's going to need to happen while you're under sentence. Do you have any questions about anything?
no,
Anything you want to add?
no.
Okay. Well, Ms. Nesby, I find there's a factual basis for your plea, and that your plea is voluntary. No one forced you to do this, and it's knowing you've understood what we talked about. Do you agree with both those statements?
Yes.
Do you mind if we electronically sign your name to the indictment indicating your guilty plea to the 2 misdemeanors?
I don't mind.
You don't mind. Good. Ms. Wood
I don't mind either, Judge.
and Ms. Smith? No minding all around. Good. Thank you.
Thank you.
What's the status of your shoplifting case out of Alpharetta?
I haven't been to court for that, but when I got out for that, I got a UJR, so I haven't had a follow-up.
Okay. All right. Well, don't forget about it. You don't want to become unintentionally a fugitive.
Okay.
But that's not this case. So Ms. Nesby, what I'm going to do is sentence you on count 1 to 9 months probation and count 2 to 9 months probation. So you will be on a total of 18 months probation because they'll run consecutive to each other. Special condition number 1, no contact with Mr. Williams. There was this reference of a second victim who's the other coworker. I don't know how important. I think this Mr. Williams is the one she needs to stay away from.
That's correct. Well, the altercation with both of them, so.
I'm not disputing that, but if was the coworker, oh, that was his new girlfriend. You need to stay away from both of them.
Okay.
You'll just need to get those 2 names to Ms. Nelson. I mean, Michael Williams she has, and then New Squeeze, whatever the name is. So no contact with either of them. Also need to stay away from that Waffle House, just in case he's still working there, just only 18 months, and gosh, there are 800 Waffle Houses, so don't go to that one. You'll need to take an anger management course. That'll be a thing that would be the other voice in your ear, not your sister saying, let's not go in that Waffle House. And then finally, 30 hours of community service. You need to take that anger management course within the first 4 months of probation, and you need to complete those 30 hours of community service within the first 6 months of probation, okay? If things are going well after a year of probation and you want to have Ms. Wood reach out to say, hey, could we do an early termination? I'm open to hearing that. I'm also making it 18 months rather than 24 months. Ms. Wood is going to have you fill out a form that has a bunch of blanks. Please write more legibly than this person did about how to contact you. And misdemeanor probation will reach out to you to set up whatever that first meeting is going to be. Don't miss the first meeting. Anything else, Ms. Wood?
No, Your Honor.
Ms. Smith?
Nothing further, thank you.
Okay. Good luck, Ms. Nesby.
Thank you.
Right, so just call me with it. And Judge, we did that paperwork before court, so Ms. Nelson already has it.
Well, fantastic.
May I
Yes,
be
you're done.
excused?
Yes, ma'am.
Thank you.
What about who had the walk-in?
I did,
Okay,
we want to talk about it now?
if it's quick.
Yes, quick. I have so he missed court back in.
And he is, just so I'm,
Previous Taylor.
case number?
It is 25 SC 004786.
All right, I see Montravius Taylor's name, and it looks like he missed plea and arraignment in September of last year.
Yes, Your Honor. And he has been in a drug program for the last 18 months.
Well, good for him.
He reached out to me and so did his bail bond, and he's been here the whole time. And he provided me a certificate of completion of the program. So that's what he's been focusing on that. And then I guess when he came to light, got all clean and, working, then he reached out and was like, oh, I have this court date and I want to make sure I don't have a bench warrant so he can resolve his case. He's working at CKS right now, and I have an address to provide the court, and I've already talked to Ms. Smith, and she's has no objection to sign the bench warrant.
So this completion date is before the plea and arraignment, so I'm not seeing the connection between being in this program and missing court.
I believe he was in for 18 months, maybe.
I was in there for 18 months.
Maybe.
You might have been there for 100 years, but it says that you completed it on July 27th, and court was a month and a half later.
I have no idea that I had court though, while I was in the program.
You weren't getting mail at
I wasn't getting mail at the program. I
at
was
Sober
in.
Living?
No, I wasn't.
Okay, the address we have for you, well, there are 2. One is Gilbert Place in Forest Park,
Never heard of it.
and the other is Campbellton Road, 1573.
That's where I got in trouble at. I couldn't go back there.
Good, don't go back there.
Right.
But we got a new address for you?
Yes. Got me and 2 of my roommates got a house now. So
Okay, and so you have a change of address form?
I will fill that out now.
Great. So we'll have a change of address. We'll get that in there. I don't know what the Gilbert Place is. And the bonding company knows your new address?
yes.
Okay. All right. Do you understand what you're charged with?
No, you can tell me.
You are charged with criminal damage to property, obstruction of law enforcement, and terroristic threats. It's from August of 24. So it's a long time ago. You were indicted in August of 25. But you busted up a car of someone named Champagne Tenney.
That's when I used to drink. That.
Okay, you shouldn't talk about it right now, just letting you know. But that's the situation we're in. Okay? And then when the officers showed up, it says you headbutted one of them. That's not nice. And you told an officer you were going to do something bad to that officer. All right, but you're remembering the situation more or less. Ms. Rios will help you remember the situation. I'm letting you know what you were charged with, okay?
I will do a waiver and that to get on the scheduling order.
Good.
We can get this process.
You'll do a waiver. You've got the change of address. Ms. Smith doesn't oppose the bench warrant set aside or the judicial hold set aside, so I'll do that. You just need to keep us posted if you move again, okay?
Yes, sir.
Does it seem like you'll be able to stay in this place for a little while?
Be here for a minute.
Okay. We're working at CKS, so I know you're getting paid all right.
Yeah.
Do you have an okay shift?
Yeah, I work night shift.
Okay.
I started off in the morning shift, then I moved to night.
All right. Well, they've been real good at hiring folks who are coming out of addiction. So,
Yeah. You know. I said, you know.
I do. And I hope that you take good advantage of that opportunity to have a paying job.
I'm trying to.
Okay. Ms. Smith, anything else on Mr. Traylor's case? Okay. All right. Then you're good to go. We'll get that paperwork signed. Thanks, everyone. All right, but he's not going to be on, okay, I'll take this part. He's not going to be on misdemeanor probation, so. It's all right. I got it. No, I don't carry around whiteout.
Yeah.
But Ms. Simpson has correction tape. Thank you, Ms. Rivers, and thank you, Ms. Hardy. Some of those were slightly involved, please. Appreciate your time today.